Ever since we met last night, I've been trying to keep my distance. I just wanna play my cards right. It takes one false move and you'll be gone. But maybe it's alright. I can't tell if it's the right moment, but baby, anyhow, I can't hold it in anymore. 'Cause it's starting to come out. Starting to come out. I've been holding it in for too long. Yeah, it's starting to come out. Starting to come out. And I can't pretend anymore. Oh, I'm yours. Never thought I'd even try. After just one day, it's special, yeah. But there is something in your eyes. Ooh, one false move and you'll be gone. You made me, it's alright. I can't tell if it's the right moment, but baby, anyhow, I can't hold it in anymore, no. 'Cause it's starting to come out. Starting to come out. I've been holding it in for too long. Yeah, it's starting to come out. Starting to come out. And I can't pretend anymore. Ooh, I'm yours. Starting to come out. Starting to come out. Starting to come out. Ooh, I'm yours. Starting to come out. Starting to come out. Ooh, I'm yours.
Não é só na vida que a vida não é na janela que se olha. Há uma linha clara perto da saída. Fecha os olhos e você vai ver. Não é só aqui que sol ilumina. Coisas do além que vão além. Quando de repente é coincidência, nem precisa se esforçar pra crer. Apagaram as luzes pra eu ver. Saí da onde vim pra eu poder ser. Você mostrou o caminho pra eu andar. Eu disse é pelo mar que eu vou nadar. Não é só na vida que a vida não é na janela que se olha. querer. Apagaram as luzes pra eu ver. Saí da onde vim pra eu poder ser. Você mostrou o caminho pra eu andar. Deve ser pelo mar que eu vou nadar.
Y'all are something else. I can't believe it. All right. Here we go. You said I'm back like the jurors cough. Oh my God. Y'all are something else. All right. Welcome back. Let's get it back on the record. We're not going to be back on the record just yet, but for those of you all who are watching, we are back on the record. You said that title is sending me, Mike. I love you so much for that. Darrell Objection Brooks. Oh my God. Let me get this back up. All right, y'all. Don't forget to hit that like button. Let me go ahead and get this back up. What do y'all think these closing arguments are going to be like? Oh, and by the way, if you hadn't had a chance to go over and subscribe to my new one of my new YouTube pages, Dad I Wish I Knew. Dad I Wish I Knew. All the things from a variety of dads and moms who love dads and kids who love dads, the things that we wish we knew. So I'm trying to build this page up. And we're going to start live streaming things from here. One of the things that we're going to do from here is a problem-solving court. Let me take this banner down. Sorry about that. Problem-solving court, where, we're going to have juveniles or children that want to just get a different perspective on things relative to their problems or whatever the case may be. Have them, it's not just limited to them. That's where I want to start. Have them come on Zoom or come on live and then just have those problems get solved, from a different perspective. Of course, having the parents somewhere in the Zoom feed or the video feed, stuff like that. And so, yeah, so that's what I'm looking to do. So just stay tuned for that. So yeah, Dad I Wish I Knew. That's the YouTube page. And if you would be so kind as to go over and subscribe, if you value that type of stuff, So let me go ahead and kind of get this out so I can go ahead and get the feedback up. Hope you all are doing good. We're going to get back on with the trial in the matter of the people of the state of Wisconsin versus Darrell Objection Brooks. That's not his name, but Darrell Brooks. TV Judge Mike. Yeah, you said Steve Harvey should give you a job on his bench. Nah, Steve Harvey likes his own thing. Plus, I do want to bring in juveniles, perhaps, and have them kind of work out their issues on here. I think that, a child not embraced by the village will burn it to feel its warmth. And I think it's very, very important that we do the best we can to try to encourage them to be their best. And the only way we can encourage them to be their best is if we get them involved in the problem-solving process. Sometimes, I hate to say it, but sometimes with parents, the intentions are well, but they don't always have the best resources. They may not have always thought of things, of how to, do what they need to do, in essence, to make sure that the child knows what they need to know. Okay. And so that's very important. So I'm kind of stalling between talking to make sure we got this live feedback up. We do have the live feedback up, and we are waiting on Darrell Objection Brooks. You said Darrell does not consent to being called that name. Darrell doesn't consent, Brooks. The sponsor of the last live stream was Megan R. Thank you very much for your $10 donation. Every $5 donation that you donate goes towards getting a kid one of my social emotional books. I like just going and being able to pass those things out to parents who are actually going to use them. Okay. Oh, me and my wife can't agree on vacation destination. Gonna get on Mike's divorce court. Oh my God. The cases are real. The litigants are real. The judge is fake. And for the record, my name is TV Judge Mike, Instructor Mike. I am not a judge. I am not a lawyer. This is not legal advice. Okay. I'll say again, I am not a lawyer. I am not a judge or an attorney. This is not legal advice. This is purely for entertainment purposes only and for educational purposes only, for you to get just a little bit of a different perspective on things relative to the criminal justice system and other matters that I can take my knowledge, skill, and ability and expertise, whatever that may be, and apply it to you. You find value in it, take it, use it. We will be back on the record. Can I hear? Oh, yeah, I hear her. Okay.
That's from yesterday too. You guys.
Yes, Ken Ross, you can represent some of the litigants.
Do you have the sheets for me? From the yellows.
All right, if you all could do a favor,
Yes.
and like. Please like the broadcast. Please share. Thank you. Please like the broadcast. It does help the algorithms. Okay. I know some people will be coming on a little bit later. They had to get some lunch, stuff like that. We got 40 people watching, 14 likes. If you would be so
All right,
kind.
it's 2 o'clock. I'll call the case. State of Wisconsin versus Darrell Brooks. Case number 21 CF 1848. May I have the appearances, please.
We're back on the record.
Good afternoon, Judge Swapper, Leslie Daisy, and Zach Wichow, agreed for the state.
I'm here without prejudice by special appearance. Beneficiary, I'm here under fraud, menace, duress, and extortion. Judiciary, Jennifer R. Darrell. This is the social security, SESTQ, trust action, which you are a real party and interest to.
What?
Sue jurors and propria persona. This is a military admiralty tribunal and maritime law. Title 4 of the United States Code Section 1, which you can see, which states placing
They did switch seats.
fringe on the national flag is within discretion of president acting as commander-in-chief of the Army and Navy. Is this common law court or admiralty court?
What the f?
The record reflects that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing a dress shirt. I know he has a suit coat, but it's not on. He's also wearing a mask. The court is not going to address any of the issues that he is raising, as they are meritless. I would also say the same as to the notes that he passed while he was in the other courtroom. For the record, I did provide a copy of all of those to the state as well. They are also uploaded into the file and are made part of the record. To the extent that he raises objections or lack of consent, it's noted for the record.
I was about to do that and say that I don't consent to being called that name or identity. That is the trust name. It is not me, myself. I don't recognize that name, nor do I consent to being called by that name. With all respect, Your Honor.
Noted.
We still have yet to address subject matter jurisdiction.
Here he goes again. Oh my God.
The record. I received those original copies time-stamped.
All right, I need to create a record of one part of the jury instruction that I do need to advise the jury. It will also be corrected in the packet. I believe within the last year, the jury instruction on credibility of witnesses was modified by the jury instruction committee, and it was just an oversight on the court's part to not include, it's really just one paragraph. It was read to the jury at the beginning of the case with the preliminary instructions. But it is a paragraph regarding implicit bias, and so I do think it's important to advise the jury of that. I intend to do that when they come out. And then again, the full instruction will be amended so that it's in the packet that goes to the jury. And Madam Clerk, if you haven't already, if you could print off page 72. It's the, it adds a paragraph before the last paragraph that starts with, "There is no magic way for you to evaluate the testimony." And again, I wanted to be consistent with the most recent version of the jury instructions and consistent with what's instructed or provided to the jurors at the beginning of the case. And so I will make sure that they have that and so advise them when they come out. Also, I will read instruction 160, closing arguments. Madam Clerk, if you could just make the change so that the parties, we missed that correction as well. So it's the closing arguments of the parties, not the attorney. And so I will just make that correction and make sure it's.
I accept the value and return the value of this document. And Your Honor, I requested that I have copies of my filings from earlier, time-stamped.
Mr. Brooks, I'll provide you with the copies later on. I need to continue with the instructing of the jury and have the parties make their closing arguments.
Your Honor, with all
I did.
respect, the state received copies. How come I can't receive the copies of my filings?
You know what, well, I can give you the print-offs, but I can't give you the originals right now. That's what I'm referring to, and you will absolutely get those back. I guess I was mistaken that you wrote copy on it. I thought you retained a copy for your record. So with that, Madam Clerk will print off from the record. It won't be the yellow copies just yet. I'll take that up later outside the presence of the jury after the case has been given to them. Now, in terms of the closing arguments, I did set a time limit for the parties yesterday. Each side will have a total of 1 hour. Mr. Brooks, so that you are fully aware, the party with the burden of proof, which is the state of Wisconsin, goes first. And then you, as the opposing party, will have an opportunity to respond and argue. And then, time limit willing, the state also has the opportunity to present rebuttal because they have the burden of proof. And that is provided with the excerpt from the bench book that was provided to you yesterday. It has the purpose of the closing arguments is to summarize the facts, marshal arguments, focus the issues for the jury. I just talked about the order of the arguments. The scope of the arguments are the content, duration, and form of argument are within the court's discretion. That's why I set a time limit of 1 hour for the parties. And Mr. Brooks, I will advise you that I certainly will wait and see how you present your argument today. I will certainly wait to see if there are any objections raised, but I also want you to be aware that if I feel the arguments are improper, I may simply, without an objection, say, please move on, as a clear indication from this court that what you are stating is not proper under the various rules and case law that govern closing arguments.
Again, Your Honor, without prejudice, I'm here by special appearance. I don't consent to being called that name for the record.
It's noted, sir. All right, then with that, I will have the go ahead. Looks like Attorney Upper has some issues she wants to raise.
Yes, I just have one question, Your Honor. Would I have permission to put the easel up and display some of the poster boards? I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
Where would it be displayed?
It's gonna put it like right here, and then you want me standing at this table during.
I do.
Yes, so I would just position it like right here. And I don't have to leave it up through the whole thing. I realize it blocks the view of people in the courtroom. Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
I trust it won't block Mr. Brooks' view of the jury, and
That's
as long
right,
as,
yeah.
Polls up.
Like, right out here, so that.
I appreciate you all being here. Just wanted to let you all know
with
that.
that caveat, yes, I will allow that.
All right.
Objection, what is that? What is supposed to be put up?
Now, who said I don't consent to being here? I want to see who's going to answer that.
Admitted, Your Honor, it's exhibit 15 and
Love you guys too.
130, I believe.
So are they exhibits? I'm confused to what they are.
Mr. Brooks, I've made a ruling. The state has made a request. I've granted it.
Yeah, but
In
I'm
terms
saying
of,
I don't understand what's being shown. Should not have the right to ask, to object and ask what it is that's actually going to be shown.
the state's put on the record what it is. It is, they are exhibits that have previously been received by the court during the course of this trial. That is proper for a party to do that during its closing.
Hey, JFB.
Can I put up exhibits?
Mr. Brooks, I don't know what you have planned for your closing argument.
I'm making a request, the same request. May I be able to put up?
What do you have planned for your closing argument? Jesus Christ.
Sir. So I'm not going to take up any more time because what I intend to do is once the state goes through its closing, I may take just a short comfort break depending on how long it is. And if there's something in particular, you will need to tell me what it is. As long as it's an exhibit from this case.
Please hit the like button, please. Thank you very much. If you value this.
From this case,
Thank you.
Obviously. It's just not nothing that the state had.
Thank you, sir.
I'm not aware of exhibits that the state wouldn't have, that you would have. Everything that's been received, we have a list. So if it's not something that was received during this trial as an exhibit by the court, unless you tell me what it is so that I can make a ruling, I can't see how it would be relevant or appropriate for your closing argument.
They're part of my filings that you filed.
The filings have no relevance to the issues that are before the jury. The closing arguments are to direct the jury so that they have your arguments so that when they go back to determine the issues in this case, which are related to whether you're guilty or not guilty of the 76 charges, things like subject matter jurisdiction or like that would not be something that would be proper before this jury. Those are legal issues that the court would decide. The jury is the judge of the facts. The court is the judge of the
But
law.
the facts is, my
All of these
honor.
jury instructions to give to the jury.
I'm not referring to subject matter jurisdiction.
What are you referring to then? Be very specific so I can make a finding and ruling.
I was specific, my other filings.
That's not
filed.
specific enough,
My-
sir. What are you
my
referring
court
to?
docket
Which
sheet.
filing?
Let me know when you're done, Your Honor.
Which filing, sir? Not generally, but specifically.
Are you done?
Are you done? Is we finished or is we done? Oh,
Sir, that's very rude and
I
disrespectful.
didn't know if you was finna say something.
I
That's why I'm
paused.
asking, are you done?
Which?
is we
What
finished?
filing?
How come
referring
every
to?
time
Or
I try,
is we
even
done?
when I try to err
New
on the side of
poll.
caution, you
New
find some way to
poll.
make it to be something that it's not. I didn't know if you was gonna say something else.
I've asked a question, sir, so when I do that, I would hope it was conveyed to you. I'm looking for an answer. So which filing are you referring to?
All my
Specific-
filings, my notice of appearance, my statement of particulars, my bond, the court docket sheet, all of those filings.
The request to display those to the jury is denied. It's not relevant.
How is it not relevant? Not even your
That's my
oath of office?
determination, sir. So I am going to start this.
Not even your oath of office can be shown?
No, that is not relevant to these proceedings, sir.
It is.
It's not relevant in front of the jury.
Why is it not relevant? Can you
Mr. Brooks,
explain
you're
why
not
that's not
going to be
relevant?
able to raise those types of issues and present a closing argument based upon my oath of office, whether I'm licensed to practice law in the state of Wisconsin,
I said your oath
whether
of
there's
office.
subject
I didn't
matter
say anything.
jurisdiction, whether you consent to this appearance or not. None of those things help the jury determine the issues in this case, which are related to whether you are guilty or not guilty of the 76 charges that have
The
been
jury
filed
should
in
know
this
that
case.
they should know the truth in their duties, in their rights. They should know that at least.
Mr. Brooks, I'm putting you on notice that if you continue with this insistence upon presenting information that's not properly before the jury as evidence in this case, that I will instruct you during your closing argument to move on and potentially ask the jury, have the jury leave so that I can admonish you. And if you keep insisting on that, sir, that will be in direct violation of the court's direction.
So they can't even know that I got a shock device on my ankles.
They absolutely do not need to know that.
Why
So it's
not?
not relevant to the determinations of guilt or innocence in this
It's the
case.
truth.
Mr. Brooks, your custodial status is not on trial here.
Boy, they put the big wigs on here.
I would argue that
She's the chief judge.
November 21st of 2021 is.
that hasn't been
on trial.
proven.
She's the chief judge in this
You may not
county.
Bring up the way that you've been shackled. It's not relevant, sir.
It's
And if
the
you
truth.
do so, you do it at your peril, but here's the
There
thing,
is
the
no
jury
peril.
is specific.
It's my right,
No,
though.
let me go. Okay,
It's my constitutional
is-
right. Just like
There are
under the
certain
First
things
Amendment,
that-
which I preserved my First Amendment right when I came in.
Y'all knew he was gonna do this.
My
Right.
Sixth
Mr. Brooks.
Amendment right.
please stop. You do not have an unfettered First Amendment right. That is very clear based upon.
What do you
all
mean
the
by
case law.
unfettered? What do you mean by unfettered? I don't.
It is not absolute. It can be restricted.
So the Constitution of the United States can be constricted.
All right, Mr. Brooks, I'm putting you on notice that if you continue with your insistence on raising issues that are.
I'm going to
really a
raise issues that the
distraction,
jury needs
that
to
are-
know,
They're not. issues.
regardless, because they're under the rights of the United States Constitution.
Oh,
which is
God.
the
Draw
land.
your attention to closing instruction 460.
I'm
which will be
going
read
to
jury
let the
at some
jury
point.
know the truth, their duty and their rights under the First Amendment and under the Sixth Amendment.
You know that sounds like jury notification,
I have the
right?
To inform them of their rights of the truth.
If you guys are here, please
under the First Amendment and under the Sixth Amendment.
press the like button,
of the
please.
Constitution of these United States. You can't.
This sounds like jury
no state
notification.
law can override that.
Mr.
Any
Brooks,
law-
you intend
any
to
law
keep this up when the
repugnant-
jury comes out,
Your Honor,
because I need to
No, I
have
do
the
not. That's
state-
why I'm addressing this before
I'm not-
they come out. That's why I'm trying.
This
to
sounds
address
like
this
jury
before they
notification.
come out.
I guarantee
So it
it.
doesn't become an issue once they're in here. But under the First Amendment and under the Sixth Amendment of the Constitution, which are rights that I preserved the moment we stepped in here this morning when this proceedings started. I preserved those rights for the record. And now you're telling me that those rights are not, would you say unfettered or I don't know what you say. I don't even know what that means. I don't even understand that. But any law repugnant of the United States Constitution is null and void.
Mr. Brooks, I'm putting you on notice that you can also forfeit by your conduct the right to present a closing argument. In appropriate circumstances, the right to present a closing argument, no different than the right to testify, may be subject to
Oh,
forfeiture
God.
where your conduct is incompatible with the assertion of the right at issue. The goals that this
I bet you he
court
got on leg
has
shackles,
attempted
not zappers.
to follow throughout this proceeding are multifaceted and multifold. Number one, I do have an obligation and have done my best to ensure that this is a fair trial. However, a fair trial does not mean a defendant has unfettered rights to state whatever he wants when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process. It also includes ensuring that the closing arguments are relevant, are appropriate. This court must also be concerned with efficiency and effectiveness, and of course, last but not least, courtesy and decorum in this courtroom, what I would generally refer to as civility.
This is legit. What are we talking about, Melanie?
You do not have unfettered First Amendment rights or an unfettered Sixth Amendment right, sir. You must conform your conduct to the rules of decorum, the rules of evidence, and the rules of procedure. Well, you have a right to present relevant and probative arguments to this jury. You may not. And you may not present arguments related to such things as jury nullification, subject matter jurisdiction, the court's oath or lack thereof, if that's what you believe, whether this court is a court of common law, admiralty. All of those things relate to your claim as being a sovereign, which are frankly baseless. They're meritless. They've been debunked by many courts, including the court in the Beneby decision that's been referenced by this court previously. I will give you a fair opportunity to present a closing argument, but again, it is.
That's what I'm trying to figure out. Is this
better?
She said it's not real life.
Fact is, sir, this court can restrict your right to present a closing argument. This court has the authority under 906.11, under the various cases, including Illinois versus Allen, including Rock versus Arkansas, although Rock versus Arkansas and Chambers versus Mississippi dealt with the right to testify.
Yes.
There is a decision. I looked it up earlier. I'll just pull it up and tell you the case site so that you have it. I would direct your attention to Herring versus New York, found at 422 U.S. 853, a 1975 case, although in a footnote, it does stand for the proposition that a defendant who has exercised the right to conduct his own defense has, of course, the same right to make a closing argument. That's quoting State Ferretta versus California, or following the same logic from Rock and Anthony and Chambers, a right, even a constitutional right that a defendant has may be forfeited by conduct. This court, just like it attempted to do with regard to your right to testify and set up reasonable restrictions so as to make.
I don't think Herring versus New York is the right case. I'm looking it up.
Will be as follows, and that is, again, sir, you may not bring up matters that are not relevant to the determination of guilt or innocence. That means evidence that was not.
I'll answer your question in a minute, Marshall.
Received in this courtroom is not relevant to your.
No, you're fine.
Argument.
Just stick around. I got you.
It's not.
Please.
The arguments must be based on the law, not as you interpret the law, but as the law is. You must.
As it has been interpreted.
Arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the facts.
Already presented at trial.
And focus the issues for the jury.
You cannot introduce new evidence into your closing.
You comment on evidence, including arguing evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses. You may not convey any idea that you have undisclosed information. Neither party may vouch for a witness or otherwise express personal belief or opinion regarding truth or falsity of any testimony or evidence. It would be improper to ask a jury to draw inferences that the parties know are not true. And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge.
That's what he's going to do.
And that is just some of the guidelines for determining the proprietary of arguments that I am guided by from my judicial bench book and all of the cases that are referenced therein. So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury out to complete the instructions that I need to complete, to add to the credibility instruction, the paragraph on implicit bias, and to let them know the full instructions that they received will have it, to read 160 closing arguments of the parties, and then to have the state go first as they bear the burden of proof.
Now, Your Honor, I'll just let you make your record. I didn't overtalk you. I didn't interrupt you. Is that fair to say? I'll let you make the record. With all due respect, when will I be able to make the record? As I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
I'm denying your request to make an offer of proof regarding your appeal. It's not, I am not required to give you that opportunity, sir.
I'm not allowed to make the
Correct.
record at all.
Correct, Grandma Bev.
As I just let you did, because some of the
Sir,
issues
I have, you have told me what you want to do. I told you you can't. I've addressed
Your
the
Honor,
request.
some of the issues have been me over talking you and interrupting you. I did not do that. Even though everything that you said, you have not proven for the record.
Dude, she is
unlawful law. You haven't shown one time that is lawful for you to do what you've been doing. As far as your ruling.
Once again, I'm not going to debate with you the prior rulings of this court. There's absolutely no need at this point for you to make an offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
You will have an opportunity, if convicted, to raise every issue you want on appeal.
I'm going to inform the jury of the truth, their duties, and their rights, as I have the right to do under the First Amendment and under the Sixth Amendment. You can't just disregard the United States Constitution. You can't do that. Again, any law repugnant of the United States.
All right, you all keep the comment section slightly clean.
There's no state law that you can cite. There's no federal law that you can cite that
Just
overrides
slightly
the United
clean.
States
Just a
Constitution.
smidgen, just a little bit.
You
Mr.
know
Brooks, I
this.
direct your attention to State versus Anthony, although that case dealt with the right to testify.
Okay, so
Its
we're not
reasoning
talking about the
is
right to
equally
testify.
applicable.
We're talking about the closing arguments, correct? We're not talking about testifying, which you
Mr.
already
Brooks,
made a
I'm not
ruling
going
on.
to delay
You
any
already made a
further
ruling
closing
on.
arguments of
But
the
Your Honor,
parties.
with all due
I will
respect,
address your further request.
with all due
once the
respect,
state-
you already made a ruling about testifying. Did you or did you not?
Mr. Brooks,
So we're talking about now, we're talking about closing arguments that I said it's my right to be able to inform the jury of the truth, their duties, and their rights. That is my constitutional right.
Mr. Brooks,
You
we are at the
can't
stage
tell
of
me
the
I can't-
proceedings where it is the state's burden of proof where they get to make their closing argument.
We're talking about me though.
I understand that, sir, but
I'm gonna
your
inform them of the
conduct
truth.
right now is delaying
I'm not intended.
the court's
To delay
intention
anything.
of
I'll
moving
let
forward
you-
with the
Your Honor,
closing
I
argument.
just sat there and let you make the record. I didn't overtalk you or interrupt you. I let you say what you wanted to say. I let you make the record. I didn't interrupt you not one time.
No, but sir, you're attempting to disrupt the proceedings.
I'm
by
not
going off on a
attempting to
tangent
disrupt
into All
anything.
of these other issues, in
How-
from my
how am I-
perspective, that is in an
How am I
attempt
being
to
dishonored?
simply
How am I being
delay
in
what we're
dishonor?
doing.
How am I
So
being
you are
in
put
dishonor?
on notice. I am done dealing
How am I
with
being in
these
dishonor,
issues.
Your Honor? How am I being in dishonor of the court?
Mr. Brooks.
Jesus
I've made my
Christ,
determination.
man.
And have
I'm
I
not
not
going to
preserved my
address
rights?
this further.
Have I not preserved my rights?
If you insist on interrupting the court and disrupting the flow of these proceedings by a blatant disregard for the parameters that I've set up, you will forfeit your right to be present in this courtroom and potentially forfeit your right to present a closing argument.
Under what lawful law can you do that?
Sir, I've
You
made
can
my
hold me in
determination.
contempt by Illinois versus Allen. You can do that. You stated that numerous times.
Mr. Brooks, I want you here for the closing arguments, but
Apparently
you
you
do
don't.
not want
Apparently
to
you
follow
don't,
the
Your Honor,
rules.
because all I said was it is my right under the First Amendment and the Sixth Amendment to inform the jury of the truth, their rights, and their duties. I never once said anything about, oh, I'm gonna bring up subject matter, or I'm gonna bring
You're
up
right,
this,
sir,
or
and
I'm
I
gonna
will
bring
wait
up
and
that.
see what you have to say, but I thought it prudent, given your conduct to date and your insistence on bringing up issues that have no bearing in this case.
This is a new
We're not
day, though, Your
relevant.
Honor. This is a whole new day.
That it was prudent on my part.
It's a whole new day.
Guidance before you potentially
It's a new day.
do that in front of the jury. But
Okay,
you're right, I will wait and see.
Your Honor, it's
But I
still,
need to get going.
it's still
and I'm going to,
unconstitutional for you to
sir.
tell me that
You
I
need
don't
to
have
be
the First
quiet.
Amendment right that I preserve, or the Sixth
Mr.
Amendment
Brooks,
right
I'm
that I
going to have
preserve,
the jury brought out. I expect that you will be respectful, courteous, and quiet.
or I'll be
And when
held in
this door
contempt,
opens,
or I'll be held in
if you
contempt.
insist on making remarks, then I will excuse everyone from this courtroom and you will be removed because you will forfeit your right to be present for being disruptive.
Under what lawful law?
Illinois versus
I
Allen.
haven't been dishonorable to the court.
Madam Clerk, please have the jury brought out.
Bro, take me to
No!
take me to the next courtroom. 'Cause
You
you're
know
not
where this
gonna
is
override
going.
My constitutional rights just because you feel like you can.
Poll
You
time.
don't have no lawful law to do that. We all have constitutional rights, and you cannot trample
Mr.
on
Brooks,
those.
what you are raising are essentially issues that you can raise on appeal.
No, I'm raising them now because they need to be on the record now. Because you won't allow me to make the record as I've let you do. You even went so far as to mute
Mr.
me,
Brooks, the
which you
jury
can't
is
even.
coming
There's no
out.
lawful law to say that you
I'm
can even
advising
mute me.
you to be quiet. They're coming
Your Honor,
out.
Does Illinois versus Allen say that you can utilize the mute button? It does not.
Mr. Brooks,
So
when the
you're-
door opens, I expect you to be quiet. You will forfeit
And I
your right
expect
to
for
be
you to
present.
I expect for you to answer questions as a public servant.
Poll.
You're a public
The
servant.
jury's coming
You're
in.
supposed to serve the people.
All right.
Take me to the next courtroom. Please, take me to the next courtroom. Hold me in contempt. Hold me in contempt. Hold me in contempt. Hold me in contempt.
Me too, Jennifer.
I have
Oh my
constitutional
God.
rights that are being trampled on, and you're coming up with ways to make a lawful law where it doesn't say in Illinois versus Allen anywhere about utilizing the
Records
mute button.
reflect that the jury bailiff is in here. However, the jury is still in the hallway. I'm going to give Mr. Brooks one more opportunity to be respectful of the court's rulings, whether he agrees with them
I
or
haven't
not.
dishonored the court. I'm merely exercising my rights under the Constitution, under the First Amendment, and under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm
the
not
way that you have
disrupting
through
the
the course
proceeding. You
of
just told me you
readings.
don't have to honor my constitutional rights in so many words. You're using the mute button.
Mr.
that's
Brooks,
not
the
even in
jury
your
is
decision.
outside this door. They're not brought in
I'm
yet.
informed that the
I'm
jury,
asking
I'm informed that the
To
jury is
be
outside the
respectful
door.
of their time.
They're not in the courtroom.
I'm
They're not
asking you to
present.
be respectful of the court's ruling,
They're
whether
not
you
present.
agree with
These
it
are
or
issues
not.
that need to be resolved before they're present.
Mr. Brooks, they will not be resolved to your satisfaction.
It's not about my satisfaction. It's
has
about the
been made.
Constitution. It's about what's right.
Are you going to
Are you going to
follow the
answer
court's
questions as a public
ruling?
servant on why you're making up laws that are not in the Illinois versus Allen? It never utilized the mute button. It never said anything about a mute button.
It is clear
Why
that
am I
Mr.
being
Brooks has
muted?
absolutely no intention of following the simple rules of decorum and courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted
it?
to bring the jury out.
How can
and
you utilize a mute
He
button?
continued to talk.
That's
So, Mr. Brooks, you
Right.
have forfeited your right to
Is
be
that-
present for the state's
is that not?
closing argument.
Your Honor,
You'll
can
be
you answer
taken
this
to the
question?
courtroom next
As a
door, and I
public
will
servant.
invite you back over when it's time for your
You
closing
can't invite me
arguments.
back over. I can reclaim my right. So how can you invite me
All
to
right,
do
the
anything?
courtroom is to be cleared so that Mr. Brooks can be removed from the next courtroom, and I'll make appropriate findings when he's in the other
Yeah,
courtroom, when I
and
can
you'll
do so
mute me, which you
without
can't lawfully do.
interruption.
You can't lawfully mute me. So now you're trampling over my first.
And we are back off the record in the matter of the people of the state of Wisconsin versus Darrell Brooks. So I do want to address my Go DG, or it's supposed to be my guy, just because he sent out, I'm going to sue America KKK. So here, and I know what you meant, America. So here's what I need for you to do. What's your purpose here? Because I've got somebody else here, but at least Malik was allowed to state his case and get into a slight back and forth, but he's providing a level of decorum, right? In controlling himself and, you know, respectfully dissenting and things of that nature. You, on the other hand, I need you to quickly state your case or state your last words. Under Illinois v. Allen, I'm going to eject you from the court. So state your purpose being here. Give me a reason why I should have you stay, or state your last final words so I can go on ahead and send you on your way. You said the defense can cast doubt in closing arguments. This is a major violation. But you're not stating, see, everybody else, me, the judge, state, everybody has been using case law to back what we've been saying. You two, right? And you, Malik, at least you've been more respectful than, I don't know who the my God guy is, but at least you've been more respectful, so to speak, in your dissent. I'm saying, in your dissenting argument. I don't know who the my God guy is, but you're going to have to say something, or here's this. Stay in the audience, write down your stuff. You said, I hate the truth. No, it's not the case that I hate the truth. You're just not stating. You're doing exactly what Mr. Brooks is doing. There is a saying, I'd rather be silent and be thought of as a fool than to speak out and remove all doubt. That's it. I'd rather be silent and be thought of as a fool than to speak out and remove all doubt. And that's what Malik, even you, right? With all due respect, I'm still waiting for, you said send them to the other courtroom too. Yeah, I'm just saying, provide evidence to back up your claims. Every time somebody says something, I'm going right to the computer, researching that case law. Well, calling yourself super intelligent doesn't necessarily mean that's totally fine. And I don't want to take away from that, stating that you're super intelligent. You may in fact be. But the next comment you must cite has to be case law. Everyone in here, sheep or sheeples. Outstanding. So, pursuant to, and we're going to make this official. Here we go. Pursuant to Illinois versus Allen, 397 U.S. 337, 1970, a defendant can lose his right to be present at trial if, following the judge's warning that he will be removed if his disruptive behavior continues, he nevertheless insists on conducting himself in such a disruptive manner that his trial cannot proceed. If he remains in the courtroom, he can reclaim his right to be present as soon as he is willing to comport himself with decorum and respect. 397 U.S. 342 and 343. So here's what I'm going to do for you. We're going to go on ahead and put you in timeout. Bow. So we're going to go on ahead and put you in timeout. And then when you come back, conduct yourself, right? You've been blocked for 5 minutes, right? Then when you come back with some decorum, and the next is going to be out of here, right? That's what the judge should have done, except in this matter, this guy isn't, peace out, no doubt. Right. This guy isn't a defendant, but guess what? The defendant in certain cases has to be in the courtroom for trial. You are a wonderfully, how do I say this? An appreciated observer. Okay. You're an appreciated observer. Yeah, absolutely. You said this judge is an angel for sure. For sure. Absolutely. So, yeah. Malik, we want you in the room. I've told you that, and I've actually told everybody to give you somewhat of an opportunity. If you're going to make a statement, which I invite you to, please, by all means, cite some case law. Cite some case law. Cite some case law. Cite something, because people just doing a bunch of talk. Cite some case law. We knew this was going to happen. We haven't even gotten to closing arguments yet. And the defendant, Darrell Brooks, is in the other room. You said, just don't defend murder. What do we mean? Well, there is no defense in this case. I don't see a defense in this case at all. At all. I don't see a defense in this case at all. There is no defense for this. Thank you all for the likes. Appreciate it. Thank you all for the likes. Yeah, you all called it. Malik said, who want to bet this case gets thrown out because of the judge's continuous threats and actions to the defense? Say something about the defendant's behavior. Malik, say something about the defendant's behavior. No, I haven't. Who said I said that Darrell was innocent? I never said. Thank you very much for that, Bruce. I never said that Darrell was innocent. What are we talking about? Jennifer, you said, can he plead mental at this point? Nah. Yeah, he wouldn't even be able to, because we're not at that stage. You said, maybe I need to blow my nose. Sniffing is annoying. Well, let me put you in timeout for a minute so then you don't have to worry about hearing it. Because I have sinus issues. So I'm not, this is all distraction. So now I put you in timeout so you don't have to worry about hearing it. And then, you know, when you come back, then you can unscrew that. That is correct. The defendant does not show compassion for the victims at all. You said his behavior will be considered in appeal because it's also on the record. Absolutely. Absolutely. Hey, Mike, what's going on? That ship has sailed on the defense strategy. Absolutely. At best, an appeal is possible, but he is unarmed in a battle of wits. He already proffered his defense, meaning that he proffered nothing. Oh, Craig, what's going on, sir? Got a question. Do you have I got to talk to you about some Max. Yeah. Hey, Roxana, what's going on? Yeah, we'll definitely put some people in some time out. You know, and then when you come back, you said she is off the bench, which is dishonoring the court. Malik. Yeah, I'll sniff whenever I please. Absolutely. You said she's off the bench, which is dishonoring the court. That's proper procedure. And that's what I'm talking about. I hope you don't represent yourself in court because you won't be able to get anything done. You won't be able to get anything done. And it's like, if you don't cite case law in your trial, how are you going to cite it at the appellate phase? Same thing for you, Malik. I've been waiting for you to cite case law. I've been waiting for you to say one thing, just cite one thing about his behavior
in the courtroom, please.
You don't approve of.
We are back on
and
the
you haven't
record.
said anything at all.
Appearances are as they were before, except that Mr. Brooks has been removed to the other courtroom.
We're back on the record.
The court did that because we came out on the record at 2 o'clock following the lunch break. Mr. Brooks was brought to the main courtroom.
Oh, that's you too?
And
under what lawful law?
35 minutes or so, he was insistent on raising a variety of legal issues with which this court has either previously addressed or which are meritless and do not warrant any further response. He is insistent on making a record and an offer of proof. This would not be the appropriate procedural mechanism, meaning an offer of proof at this time. We are not in the midst of a trial where the court's made an evidentiary ruling that would require the preservation of the record by making an offer of proof. This court has been attempting, frankly, all day to get through the reading of jury instructions, to get to the point where the parties make their closing arguments, and ultimately to put this case in the jury's hands. It has been challenging. It has been met by resistance from Mr. Brooks.
That you've allowed.
I would once again describe it as being stubbornly defiant, although at times he may wait for me to make my ruling. He continues to not respect the fact that a ruling has been made.
Malik got put in timeout for 5 minutes.
And re-argue points that this court has already gone over. And in an effort to simply put him on notice regarding his behavior, given the history of this case, the court was attempting to set some parameters regarding closing arguments so that they are focused, so that they are proper, and that they follow the law. That was met with a considerable amount of resistance and repeated statements by Mr. Brooks.
That you've allowed.
He has First Amendment rights, Sixth Amendment rights, 14th Amendment rights. He has all of those rights. That is not in dispute. But those rights do not come in a vacuum when we're in a court proceeding, in a trial such as this. The rules of evidence, the rules of procedure, the rules of courtesy and decorum all apply. And this case has demonstrated that a stubbornly defiant defendant can forfeit even important constitutional rights by conduct. That includes the right to be present, it included the right to present further witnesses and testimony, and it included the right of the defendant to testify on his own behalf. I hope that I do not have to go through a decision that forfeits his right, or that makes a finding that he's forfeited his right to make a closing argument. I will certainly wait and see how that goes. I would note he was very respectful when he did his opening statement. It was clear. He made a variety of points. He did so in a way that I would say was very conscientious of people's time. It was cogent. It was concise. It was probably about 35 minutes. I may be off a little bit, but that's what my memory is. It wasn't overly lengthy. I would hope that he follows some of those same things here when he does his closing argument. But he has been removed from this courtroom because of his stubborn defiance and disrespect of this court, of courtesy and decorum. And what I truly believe is an effort on his part to continue to delay and lengthen these proceedings. I've said it before, I'll state it again. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. And trial courts and trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. They noted 3 constitutionally permissible ways to handle such a stubbornly defiant defendant. But they also indicated that no one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. I've noted this before. This is a case from 1970. The technology that we now have in this brand new courtroom was not available then. I have the ability to have Mr. Brooks appear from the other courtroom by way of audio and visual means. We can see him, he can see us. I confirmed prior to calling the case that the audio was working, that the video was working. The one camera, there's 4 cameras in my courtroom, there's 4 cameras in his courtroom. However, it is set to 1 camera since he's the only individual there. Other than the bailiffs, but I'm talking about as a party to the litigation. So the courtroom, the cameras in my courtroom include one that would normally be on the witness stand that has been zoomed out so as to capture the large majority of the jury box.
Yeah, I don't think it's going to be a mistrial.
I even adjusted the camera that's on the state's table so that the exhibit that's currently up to my left, her right, Attorney Upper, is viewable in the camera angle, and she is still present within, meaning viewable within that as well. And although I've made a finding that he has forfeited his right to be present for the state's closing argument, I'll find that the technology that I have available, it is that his appearance from the other courtroom is the functional equivalent of appearing in this courtroom and being present due to the technology that is available. I do have him on mute for the time being because I needed to make a record, and there is a very lengthy history with Mr. Brooks during this case of him talking over me and my inability to make an adequate record if I am in a constant back and forth with him and trying to talk over him. And so I, yes, made the decision to utilize the mute function on the incoming audio. I know he disagrees with my ability to do that, but I believe it is consistent with ensuring dignity.
Turn your
and
back
decorum,
on me.
that when appropriate, he be muted. I will advise Mr. Brooks once again that although he has lost his right to be present in this courtroom, he can reclaim the right to be present as soon as he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. That includes not interrupting the court. That includes respecting when the court renders a decision by way of an oral ruling, even if he disagrees with it. So with that, I will advise him that once the jury is brought out, I will unmute him. I expect that he will be respectful of them, and I expect that he will not interrupt as the court goes through the couple of final jury instructions I need to go through.
I think Shanice got it. I know she
Including
did.
the reading of jury instruction 160, closing arguments of the parties. And then I will turn it over to the state, but I will unmute him at that point. So should he have an objection, he will be able to state objection. I will be able to rule on it. And again, I expect him to honor whatever the ruling that is made. And if he does not do that, then I will utilize the mute function. If he doesn't have it, we'll make sure he has the objection sign. And if I see that, I will unmute him to hear what it is and then make a ruling accordingly. Attorney Hopper.
Your Honor, 2 quick things. Please, could you confirm that the audio and video are working in the next courtroom? And the clerk's shaking your head based on that. Thank you. I don't know if you want to do it now or at a later time, but I think we should make a record as I will be displaying a PowerPoint during my closing argument, throughout my closing argument, and I'm not sure how that is projected in the next room or how it affects what we see in this room, Your Honor, but we should make a record of that at some point.
Thank you. My understanding is Madam Clerk has the ability so that it's displayed not only here, but in the neighboring courtroom. If you would be so kind as when you start displaying it, just make some type of record. Excuse me, so that the bailiff is over there. It's not being properly viewable.
That's not
viewable.
That's not me with the echo. That's on there. That's their feed.
Thank you. If you would like, before the jury comes out, we could do a test. Yes, could we please?
That's their feed. And he gets blocked. Bam. See how fast that was? Gave him a chance. Blocked.
Could you confirm with the clerk over there that the PowerPoint is also viewable? You can see it. All right, and it should be similarly to what we see. So the monitors will display the camera that Mr. Brooks is appearing, that is on Mr. Brooks on the left-hand side of the TV, and then the 4 cameras for this courtroom on the right-hand side, but it's probably maybe a quarter to a third of the screen, and then the remainder of the screen is the PowerPoint. The monitors in the courtroom that Mr. Brooks is in are no different than what they are here. You would have one at the table, but there would also be the very, very large TV monitor.
Malik needs 5 more minutes. Malik needs 5 more minutes.
It would be very similar to what is here if you were present in this courtroom. And again,
Under Illinois versus Allen, Malik needs 5 more minutes.
It's probably not the most easily seen from a camera, but it's really no different than what I'm looking at the moment. So I appreciate you asking that I make a record of that. I would further make a record that there are headphones on the table
Ugh.
where Mr. Brooks is currently standing. He has not put them on, but they are available should he want them. All right, then I'm turning off the, all right, PowerPoint. Let us know when you need that function, and then Madam Clerk will be able to make that viewable in both courtrooms. Very good, thank you. All right, with that, the jury is to be brought.
Yeah, that's not me. I just checked Court TV's feed and it's the same sound. So that's not me. And it's the same sound. So, yeah, that's Court TV's feed. I mean, that's the court's feed. That's not me. Court TV has the same sound.
All rise for the jury, please.
SS lost cause. Thank you, Bruce. Love you too, buddy.
Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, when I read the jury instruction to you previously regarding credibility, I had a prior version of the jury instruction. Now, what I read to you in the very beginning, or at the very beginning of this case, was the most recent. I am going to read a short paragraph, but also tell you that in the packet that will be sent with the jurors to the jury deliberation room, it will have the complete instruction.
Sorry.
It's instruction number 300, excuse me. And this is what I want you to know about credibility. In the determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. With that, I will ask Attorney Opera to start with her closing argument. Go ahead.
And then clerk, if you would please turn on the PowerPoint.
Yes.
You're fine. You're fine, B. Thank you, Frankie.
Hold on 1 second. Mr. Brooks, do you have an objection?
I thought I was supposed to be unmuted.
You are now. All right, Attorney Opera, you may start.
Thank you, Judge. Good afternoon, everybody. It's kind of nice to stand in the middle of the courtroom, you know, all week or the last 3 weeks, they shoved me at the end of the table because I'm the lefty in the group. It's nice to be able to look at you all and say thank you. Truly thank you. Each and every one of you, I want to express our sincere gratitude from the prosecution team, myself, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Richell. There's no one in this courtroom that does not realize the sacrifice that you've made serving your community in this very important task. You've put your lives on hold. I don't even want to hear from your bosses. Thank you. You've watched these proceedings and you've noticed as we sit at our prosecution table, we don't have a client at our table. But rest assured, we do represent someone. We represent the people of the state of Wisconsin. It's an entity. I can't bring it to the courtroom. People enact laws. People want to feel safe. People have representatives in Madison or Washington, D.C. that set standards, rules that we all are expected to live by. And when those rules are violated, prosecutors step in and enforce the law. Darrell Brooks does not represent anybody. He does not have a client. Darrell Brooks is the client. Darrell Brooks is the defendant. The state of Wisconsin is the plaintiff. It's really that simple. And it's consistent with any other criminal case you've ever heard about at any other time in any other jurisdiction. It runs the same, no matter what state or federal. I'm going to ask you for your guilty vote at the end of my comments. It's up to you. I can't tell you to do anything, except I'm going to say one thing to you that I wholeheartedly ask you to obey.
Attorney Alper, I'm sorry for the interruption. Your objection, sir?
Mischaracterization of who I am and the way it was said. I feel like it was talking down.
All right, your objection is noted. It's overruled. The state may continue.
You must not
You've unsubscribed? Okay, good.
consider anything about Darrell Brooks other than his conduct in downtown Waukesha on the evening of November 21, 2021. Nothing he's done before that, nothing he's done since that. When you go back to that deliberation room, please obey Judge Doro. Confine your comments to his conduct on November 21 of 21. Is he guilty of the 76 counts that he's been charged with? That and solely that should be your topic of discussion. So, what are the charges against Darrell Brooks? Thank you for your patience in listening to the jury instructions. They must be read for each and every count. But sadly, they can be summarized very quickly like this as far as the actual counts. Counts 1 through 6 are first-degree intentional homicide while armed with a dangerous weapon. Counts 7 through 67, first-degree recklessly endangering safety while armed with a dangerous weapon. Counts 68 through 74, hit and run causing death. Counts 75 and 76, bail jumping, and count 77, battery.
Whoa.
Mr. Brooks, what is your objection?
I have 76 charges, not 77.
The bell jumping.
It's a mischaracterization of the charges.
That is correct. It is sustained. It should be count 68 through 73, I believe, and then 74 through 75, and then 76.
Thank you, Your Honor. I do apologize for my math skills. 68 through 73, 74 and 75 are bail jumping, and 76 is battery. I apologize for that misstatement. We're going to talk about counts 1 through
Why is she trying not to
67 in
hope?
detail.
She's trying not to laugh.
Counts 68 through 73, hit and run causing death, in my opinion, are easily summarized as this. He never stopped. Never. Bail jumping, he was out on bail for 2 files in Milwaukee County, facing felony charges there. He was ordered to not commit any further crimes.
Okay, so it was Milwaukee County.
He was involved in any of the conduct charging counts 1 through 67. You should find him guilty of bail jumping. Battery, that relates to the split lip and black eye suffered by Erica Peterson. we told the story kind of backwards. We started with the battery for background. First degree intentional homicide. You've seen this in our opening statement. You've heard it from Judge Darrell. Did Darrell Brooks cause the death of the victim, a victim? Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human being? Count 1, Ginny Sorensen. Count 2, Lee Owen. Count 3, Tamara Durand. Count 4, Jane Kulik. Count 5, Bill Hospital. Count 6, Jackson Sparks. Those are the individuals who lost their lives because of the conduct of Darrell Brooks. From there we go to reckless endangering safety. What is that? In this case, it means that through his reckless driving, he endangered the safety of other people. And he did so demonstrating utter disregard for human life. Now, behind me is State's Exhibit 15. It's also on the PowerPoint. If you choose, you may have this chart with you in the deliberation room to help you walk through each of these counts if you find it helpful. It's up to you. If you don't want it, you don't have to have it. But it will be available for you if you ask for it. And it'll take you, as we did in our presentation of the case, right down Main Street and address all the counts that were involved, all the counts that were charged. To prove reckless endangering safety, and I'm just going to go back one slide, nowhere do you see there that we have to prove any degree of injury to anyone. Never once did Judge Darrell instruct you that somebody has to be physically injured. Now, Detective Casey told you that was the standard we used in deciding of all these hundreds of thousands of people who is included in these charges. And the decision was made by the prosecution team to include people who were physically injured to be efficient in our prosecution. And so everybody up and down the street, I would argue, had their safety endangered that day. I didn't charge 5,000 counts. We selected 61 counts of people that we can identify by name in Exhibit 15 that were injured by the conduct of Mr. Brooks. Those are the people in green. People in red are the fatalities. And we presented this case to you in much the same fashion that is presented here on Exhibit 15 as to how the injuries occurred going down that street. So
who's arguing race?
we are absolutely held to our burden of proof and the elements for each offense that Judge Darrell instructed.
Oh, dude.
But we are not required
Put your butt in timeout.
any injury to anybody.
Timeout. Matter of fact,
Is
block.
their safety endangered by his
Person's
reckless
blocked. Moving on.
His reckless driving. Now, some of the groups, pretty easy. They walked in a formation, and you can get a photograph or a diagram, and you can kind of see pretty easily who was located where, right? And you can think back to the videos that you've seen for each of these groups and remember, and you'll see them again, the path of the vehicle as it went through each of these groups. This is South Band, of course. All of these names that are being displayed on the PowerPoint Exhibit 21 are on Exhibit 15 in green for Waukesha South Band. Pretty much the whole left half of the formation was endangered by the safety of Darrell Brooks driving up the side of that band. The extreme dance team. It's a little difficult to read. But
I'll put the link in there.
again, this chart was marked as an exhibit. It's exhibit number 33. If you want it, you can have it in the jury room. The names on this chart will match the names for the extreme dance team on State's Exhibit 15. All of the girls that were struck and injured as they marched with the extreme dance team, plus some people on the back that were handing out candy or serving in support roles as the unit made its way down the street. The dancing grannies. State's Exhibit 54. The formation that they marched in, who was located where, and your recollection of how that SUV zigzagged through that group. And you can just see the names and match it up.
I'll put that
Who
up.
was injured and killed versus who wasn't. Now, one of the big things in this case has always been, why did this happen? What was he thinking? Why did he do this? Again, those are things I don't necessarily have to prove to you. His intent, I do have to prove, and I submit without any doubt. There's overwhelming evidence that this is an intentional act
Hold up.
by Darrell Brooks.
What's your verdict?
An act of utter disregard for human life. I say that for these reasons, folks. Number one, first and foremost, just stop driving. That's it. It's really that simple. Not one person had to be hurt that day if he would have just stopped driving.
You specifically,
I just put the link in there for you.
can I be heard?
Your objection, sir?
Oh, I didn't know if I was on mute or not.
You're not?
You specifically said in your jury instructions that intent cannot be, you can't look into someone's mind, I think is what it says, to find intent. So how could that be characterized as someone knowing for sure intent or not knowing for sure intent?
You're making an argument. You'll have an opportunity to do that later. Your objection's noted. It's overruled. The statement continue.
I apologize.
We showed you at the very beginning, remember our first witness was Sergeant Warner,
He controlled
man who
himself.
was the incident commander for the parade. We put up another map. I think it states Exhibit 1. You can have that if you want it. Shows all the positions of all the police officers and the reserve officers, the barricades, the squad cars. How do I know it was intentional? Because even Darrell Brooks told Detective Carpenter, I could tell something was going on downtown. No reasonable person would drive upon this area, see the squads with their red and blues on, see the officers in the street with their bright yellow vests, see all the people milling around, see the floats lining up and the participants getting ready, and not know to drive safely, slowly, and obey officers. The barricades help us prove it was intentional. The police presence help us prove it's intentional. The parade participants help us prove it's intentional. And the parade spectators help us prove it's intentional.
Excuse me, Attorney Alford, your objection, sir?
Speculation as to what the alleged defendant said he saw. It was
Sir,
never.
Your objection's noted. It's overruled. This is closing arguments, not the evidentiary phase. Go ahead,
So
Attorney Alford.
Typically, you do not see a person, you don't see a lot of objections during closing arguments.
Continue, Attorney Alford.
You don't see a lot of
Honking the
that.
horn. Quite interesting that Mr. Brooks asked so many witnesses if they heard the horn honking. Some of them said they did at the beginning of the parade. Yeah, I heard a horn honk. Most of them said they didn't. The horn honking cuts both ways, folks. If he's honking his horn, that means he can see something's in front of him. That means he knows there's an object in the road. You can rely on your common experience in your affairs of everyday life. If you see something in the road and you want to alert the other person to your presence, you will honk. But you do not have the green light to then just keep going if they don't move. He knew they were there. Intent. I skipped one, I'm sorry. Going back to my street number 15, I failed to include the Catholic community. That's just one of the photographs showing the people that will match up to Exhibit 15 from the Catholic community of Waukesha. There's a lot of photographs identifying the people that were marching with that group. The parade started. This is the starting point, or at least near the beginning, right? This is the area. We showed some videos of the groups passing by in this area. We heard testimony from 4 different police officers standing in 4 different spots near here, telling of their 4 different efforts to stop him. Intentional. Sergeant Wanders back here testified that this red SUV blew by me. I waved both arms over my head. I'm in a police uniform. I have an unmarked squad, but I have my red and blues on. And he blew past me. He gets down here to the corner where Detective Casey is standing. Detective Casey runs out into the street, gets close enough to put his hand on the hood of the car. He keeps going. He comes down, turns on the main street, gets in this area of East Avenue to the south and Buckley Street to the north. This is where he encounters Officer Schneider and Officer Buttrin. They each make a separate effort to stop him, and he keeps going. 4 police officers. It's intentional. He had plenty of opportunity to just stop anywhere along the way. One of the officers testified to it. I think it was Officer Schneider. This was an accident, and he mistakenly wandered onto the parade route after passing all this. And he mistakenly wandered onto the parade route. At any point, all he had to do was stop. They could have paused the parade. They could have moved the barricades and escorted him. It didn't. It was intentional. He went on for 4 blocks. 4 blocks. It was intentional. He reached speeds of approximately 30 miles an hour. That's intentional. He plowed through 68 different people. 68. How can you hit 1 and keep going? How can you hit 2 and keep going? How can you hit 3 and keep going?
Strong argument.
Didn't phase him a bit.
Keep going, State.
Kept going until he got to the end, and there was no more bodies to hit. It's intentional.
Mischaracterization of the evidence.
Noted, overruled. His conduct when he left the parade route, we'll get into this. His flight, his hiding, his panic, his desperation to run. Get the hell out of town as fast as he could before the cops came. That shows his intent. His interview with Detective Carpenter, we spent several hours playing you snippets of that interview. How telling was that? Never once did he say any of these things. Never once did he say, like he told you in his opening statement, it wasn't an accident. It wasn't intentional. Never said that to Detective Carpenter. No, he came up with some convoluted story about, I got a ride out here from a buddy in a tan Kia, and then I left to go meet Erica, and we got into a fight, and then I went back, and the other guy got into a fight, and he was leaving, so I took off on foot. Absolutely nonsensical story. Does not match up with the known evidence in this case.
Overruled.
He never
I didn't
stopped.
even state the objection.
This is closing argument. She may continue.
I'm going to play this slide, which is a snippet from State's Exhibit number 53. Go ahead and play with sound, please. That was just a snippet that I selected because I thought it really captured the environment that so many witnesses tried to explain to you, right? It's a Christmas parade. People are there with their families, their little kids, their grandkids, their neighbors, their friends, strangers, standing next to strangers. That's what's going on Main Street. While that's going on Main Street, this is going on. Remember this? This is the gas station on the corner of Barstow and North Street. While the units are marching down Main Street, entertaining the crowd, Darrell Brooks is driving recklessly. He's enraged, and he's arguing with Erica Patterson. Why is this important? This is important because before he even gets to the parade route, this is how he's driving. He drives the wrong way down North Street and then acts like it's everybody else's fault in the world.
Your objection is noted. It's overruled. You may continue, Attorney Opera.
When he finally pulls into the gas station, he rolls down his window and yells at the driver who's properly stopped at the stoplight that it's somehow that guy's fault that Darrell Brooks is trying to drive the wrong way down North Street. And from there, the rage continues. We get to this point, State's Exhibit number 3. Please play. The video is playing. You can see the pushing match between Darrell Brooks, Corey Runkle, Erica Patterson, and Nick Kirby. Watch this. He turns to get in the car, flips up his hood, and goes and gets in the passenger seat. I'm sorry, driver's seat.
How long we gonna mischaracterize testimony?
Starts argument. I've heard nothing improper. Your objection is noted. It's overruled. You may continue, Attorney Opera.
Thank you.
They need to know they can nullify.
That's it. He drives off onto the parade route. From this moment, right here on Exhibit 15, you're watching it. He's enraged. He's angry. Flips up that hood, and he zooms past Sergeant Warner, past Officer Casey.
2 to 3 days.
onto the parade route. Now, there's no doubt, for the first 2 blocks, he does not strike anyone. And as we discussed, some even said he was driving at a reasonable speed initially. By the time he gets past Officer Buttrin and Officer Schneider in this area here of East Avenue, past East Avenue, and clearly once he gets past Barstow, that's where it starts, right? That's where it starts. Nicole White, our first victim, walking with Remax and hot air balloon. Knocks her over, keeps going, runs up and over the backs of Waukesha South Band, hits the green children spectating on the sidewalk, keeps going, runs over Kelly Grabo and her daughter Adelia, walking with Burris Logistics, keeps going, plows through the entire extreme dance team just before the 5 points, keeps going, hits Deborah Ramirez and her son Isaac spectating on the south side of the street, keeps going, clears the 5 points area, hits Jane Kulik square on, causing her to go up on the hood of the car, and then fall off and drives over her body. He doesn't stop. He keeps going. Runs through the kids over by the steaming cup. We heard the parents testify about little Brinley and Kelsey and Owen that were standing there outside the steaming cup. They were struck by the red SUV driven by Darrell Brooks. Keeps going. Plows through the grannies in that zigzag fashion, striking most of them, injuring them, killing them, keeps going, gets down here to the end, and goes through the Catholic community.
She's good. She's really good.
The witness, remember Holly Bird, she testified about that mobile gas station incident. She said she was standing down here in this area. She said, I saw 15 to 20 people fly in the air. They look like bowling pins. And when you saw the video, she's absolutely right. It's a terrible description when you think these are human beings, but that's exactly what it looked like. When does the intent exist? Doesn't have to be even for a second. I'm not telling you who set out that morning to cause this carnage. But when he became enraged back here, he didn't give a damn who or what was in his way. He intentionally went on. I'll show you. Motive. I don't know why he did this. Folks, I don't know why. Other than the rage. He's right. You cannot read minds. Neither can I. But the law doesn't require you to. The law gives you a way to reach a conclusion as to what is somebody thinking. And it's right here. Decide it based on his acts, words, and statements, and from all of the facts and circumstances. I've already been through many of them. I want to show you what I mean. Look at this. Was there room for him to get out? This is way back at the beginning. This is Officer Buttrin's squad video. Way back at the beginning. That's Buckley Street here that you're looking at. Look at those barricades. Look at the sparse crowd. And there's Officer Schneider in her yellow fluorescent vest on the left side of the picture, about to run into the street and stop him. Intent. I'm going to play this video for you because, folks, for me, this is where it becomes crystal clear. You watch this video, the first thing you're going to see if you direct your attention to the left side of the screen is you're going to see him hit Nicole White. Knock her to the ground and keep going. Now, if that was the end of the story, you may sit here and say, Madam DA, I don't know how you conclude intent from that. Maybe it was an accident. Maybe he didn't mean to do it. But watch what happens in this video after he knocks Nicole White down and tell me this does not prove intent. Please play. Keep watching the left side of your screen.
Oh my God. Oh my God.
That's intent, folks. No reasonable person is going to come across a group of teenagers playing band instruments, drive over them, and keep going. That's a still shot of the same thing. That's intent.
Sorry to interrupt your objection, sir.
How can you tell the jury what they supposed to think?
Proper argument, your objection is noted, it's overruled.
I will argue that it's, I will say that it's improper, and I move
Mr.
for
Brooks, I made
mistrial.
my ruling, I'm going to mute you if you don't follow the rules.
Exhibit
I move for
one,
mistrial.
Exhibit 152. Clearly intentional conduct. Clearly intentional conduct. States Exhibit 93. We ask the court to take time to have you go look at this car in person because it's remarkably amazing that this damage was caused by human beings. That's intent. This is an excerpt from State's Exhibit 154. Maybe a little hard to see. A lot of that laying in the front part of this photo are shoes. Remember what Dr. Bidritsky said about the shoes, and the feet, the scuff marks on the toes and the ankles? Look at all the shoes laying in the street. This is the area at the end when he ran through the Catholic community. All the shoes laying there because of the velocity. Remember, the medical examiner talked about the velocity. It's not just the speed, it's the velocity. The power that these people were knocked right out of their shoes. That's intent. The flight, the hiding, changing his appearance. He had to go through some effort, right? Crawled up in this playhouse, ditched his sweatshirt and his sandal. The other sandal seems pretty reasonable. He dropped it when he was jumping over a fence. Changed his appearance. Please play.
Excuse me.
Intent. What's he running from? What's he running from if he's just a lost guy with no ride back to Milwaukee? What's he running from as there's cops, sirens wailing in the background? Whoops, that was me.
Bruce, were you there? Like for real, for real?
So, State's Exhibit number 130. Put that up here quickly. Thank you. I'm not gonna go through this whole thing, folks.
Bruce, were you there?
Suffice it to say, after Officer Skolton tried to stop the threat at that intersection at the top, Wisconsin Avenue, and he blew through the barricades there and drove south on West Avenue over to Prospect Court, cutting through the yards and ditching the vehicle on Maple. Heard all the testimony about the commotion on Maple. The eyewitness testimony from Officer Sailors, off-duty police officer who saw this, saw the defendant, Darrell Brooks. He identified him for you in this court. Get out and run from this car. And how we tracked him through the neighborhood.
Oh,
Again,
okay.
Desperation. Whether he had to ask or use veiled threats like, I won't hurt you, but I need your phone. He was absolutely desperate to get out of there. Until he took refuge in the home of Daniel Ryder. Now remember the interesting thing, folks, none of these witnesses in this area knew anything about what happened at the parade. None of them were there. None of them were there. So some of them tried to help, some of them didn't. Daniel Ryder did, and it's actually probably a really good thing that he took him in because it stalled, right? It stalled them from keep running, kept them in one place until the cops could close in and get there. Now, Mr. Brooks repeatedly asked witnesses who had just watched their loved ones get struck by this SUV if they happen to catch a license plate. State's Exhibit 150, there's the front license plate. Definitely a little blurry, but definitely you can make it out. State's Exhibit 151, there's the rear plate.
No, not yet, Julie. We're on state.
State's Exhibit 175, there's Darrell Brooks in his music video with the same car and the same license plate. There's the key to the Ford that was found in Darrell Brooks' pocket. There's no doubt Darrell Brooks is the person responsible for this. Because this man in this picture is the same as this man in this picture wearing this sweatshirt. And again, it's a little hard to see, but you can ask for these exhibits in the jury room if you want. The photograph, you can see this design on the front of the sweatshirt if you look close enough. This is a sweatshirt from the playset that has Darrell Brooks' DNA on it, according to the crime lab. That's him right there. That's Darrell Brooks driving off into the parade. That's Darrell Brooks driving in the parade. That's Darrell Brooks driving in the parade. That is also Darrell Brooks driving in the parade. And so is that. And he kept asking people about the tints on the window. Well, guess what, folks? You don't need to see the tints on the window when the windows are rolled down. And there's clearly one person in that vehicle in every one of these photos. And it's that man. And it's that man. And it's that man. Darrell Edward Brooks Jr., date of birth 2/21/1982, on his identification card issued by the state of Wisconsin. In all capital letters, Darrell Edward Brooks Jr. This was in his pocket when they arrested him. So this entire shenanigans that he's presented to you through his questioning of witnesses about, I'm not Darrell Brooks and that's my name and I don't know who that is and I don't consent to being called that name. It's just nothing but a distraction. It's Darrell Brooks. It's the man who drove through the Waukesha Christmas parade and killed people, injured people, endangered the safety of people.
Sorry, is there objection, sir?
Your Honor, with all due respect, I would appreciate the quote unquote language what you mean by shenanigans and this and that and the third.
Sir, your objection's noted. It's overruled. The state may continue.
Well, can she tone that back? Because if that was me, if I would have said
Mr.
something
Brooks,
like
your
that, it would've been a
objection
problem.
is noted. It's overruled. These are closing arguments. There's
I
nothing
just-
improper. It's noted.
Just save it for closing,
I
dude.
just wanted to be fair.
You'll have an
That's it.
opportunity to respond, sir. Please let her
So I
finish.
can rebuttal?
In closing.
Go ahead, Attorney Alford.
Thank you.
Oh.
I'm going to conclude my comments with this, folks. I'm going to show you the video, a stitched together video of all the carnage caused by Darrell Brooks, and I apologize.
Stitched together.
This is important that you know what he did. It's important that you think about the women like Nicole White and Kelly Grabo and her daughter and Jane Kulik, who were just there with friends and co-workers supporting a local business. The teenagers marching in the band, representing, wearing their school colors. It's important. The boys and girls with the Blazers baseball team and their coaches doing nothing more than handing out baseball cards. The young girls in the extreme dance team. Can you imagine how many hours they spent practicing that routine? He drove right through them without a care in the world. The grannies dancing their way down the street, perfect step, every one of them. Catholic community there, as Father Matt said, spreading the light of Christ in the weeks before Christmas. He snuffed it out. It's time for Darrell Brooks to stop running. It's time for him to stop lying. It's time for him to be held accountable for his actions. Darrell Brooks cowardly rammed his way through this parade, violently killing and injuring so many people. I'm going to stop talking and play this video, but please, I ask you to add up the evidence, use the map, 15. You can check off the names. We've covered them all. Walk down that street like we did with you. Return guilty verdicts on all counts. Please. Please. No, I need one more. Yes, please. Go ahead.
We won't be able to see it. Oh, I'm good, Jeremy. She had a powerful closing, though. She could have used some looping in her closing. More looping. Especially if I had 68 plus victims. Oh, I'm looping. I'm looping. I'll tell you what a looping argument is. I guess she had to be careful, but this might have been one of those cases where a looping argument. Did y'all hear the sound of the band playing and then being disrupted by Mr. Brooks? If that isn't a demonstrative piece of evidence that will forever stick in the minds of those jurors as they go back and deliberate, man. I took a lot of notes during her closing, so. At least he's being quiet during this. You said they don't need looping? Yeah. Yeah. I think just a little bit more looping. Just a little bit more. At least going through the 6 and then culminating the rest. And now you've got the victims crying. I mean, they're surviving family members or victims in the audience. Yeah, bro.
Thank you. Before we continue with Mr. Brooks's closing argument, I'm going to take a short break. I'll rise for the jury, please.
Am I muted?
No.
Do you see her face?
The jury should know that they can nullify.
You are muted now.
News gonna happen. Ooh, this his closing is about to go down. It is about to go down. Do you think this jury is going to nullify? Not after what they seen. Not after what they seen. And I know, Julie, you all are saying that, yeah, you said I would give you the 6, but the other 67. No, you could culminate, if I'm using the right word, all of them into one big argument. But the 6, and so I know, Julie, you were saying that the jury has seen all the footage through the prosecution's case, but the jury has also been exposed to a lot of, it's okay, Bruce. It's okay. It's okay. Let me finish what I was saying, and then I'll get to you, Bruce, because your feelings are definitely justified. And never let anyone take that away from you, okay? Never let anyone take that away from you. No judgment whatsoever. That's okay. So the jury has also seen a lot of, and if they haven't seen it, they definitely have heard of it. A lot of antics from the defendant in this matter. And so I understand you all saying that we don't want to overly expose the jury to a lot of things that could cause them to move away from the facts and operate on their senses. But this is not like a crime where you got one person involved. This is a crime where you have a lot of counts of first degree with malice aforethought, intentional. You see what I'm saying? Right. Well, no, you're fine. I think that it's important to remind them, and they have been reminded, but just a little bit more spice on it, because you're speaking for the victims. You're speaking for the victims. And so I think that she would, one person, then 2 person, then 3. She could have taken it just 3 more to the 6th. To the 6th. And you said, Instructor Mike, I believe they want to minimize more exposure during closure to avoid that emotional element. It's too late. It's too late for that. You think about it. You got one of the persons in the audience who was crying. There's no telling why the judge had to take this break. You see what I'm saying? There's no telling why the judge had to take this break. You can look at the judge's facial reactions. She couldn't even look at the screen so as to attempt to stay impartial. When he started talking, you could tell by the little small facial expressions. It's an emotional trial. It's an emotional trial. You think that she talked about, for those of you all who might have heard certain things about the closing argument, so I can't look at your comments because I'm reading my notes right now, right? She was talking about the state of Wisconsin being an entity represented by the prosecutors, that society has rules and standards, and when those standards are violated, prosecutors step in and prosecute. Darrell Brooks is the client, he's the defendant, and the state of Wisconsin is the plaintiff. You got 6 counts of first-degree intentional homicide and 67 counts of first-degree reckless endangerment. Counts 68 through 73 are hit and run causing death. We might argue that 68 through 73 are lesser included, right? And then the count of bail jumping. Her main argument was he never stopped. Never stopped. He was on bail. Thank you. I appreciate that. He was on bail for another charge in Milwaukee County, and thereafter having been released from a previous charge on the condition of bail, he violates that bail by getting into a domestic situation with his ex, the mother of his child, Erica Patterson. After the shoving match between that, it results in the 6 counts of first-degree intentional homicide. Did he act with intent to kill? He never stopped. In fact, he sped up and hit Jenny Sorensen, Lee Owen, Tamara Duran, Jane Krulik, Bill Hoskell, and Jackson Sparks. In terms of reckless endangerment or reckless acts that are endangering the safety, he had utter disregard for human life. She introduced State's Exhibit 15, where in that, she said it would be available that if they asked for it. It showed the parade route. It showed the moment of impact of the 6 people and others who were hit. And she talked about in reckless endangerment, she stated there is no requirement to prove injury, just to prove that he did act with the intent to recklessly endanger the safety and the lives of those in the parade, and how she could have chosen 5,000 or however many people were there in attendance, but she chose 66 identifiable persons by name. And she looped that argument again. He did not stop. She mentioned that the defendant stated in his interrogation that he could tell that something was going on downtown. He could tell that something was going on downtown and that all those people were there. District Attorney Sue Opper continued her argument, stating, now, Julie, you said Brooks tried to use that vehicle to hit Erica 2 weeks before he did that. That was never introduced in closing. I don't know if it was ever introduced at trial. That would have been interesting to know. She said something to the effect of him honking his horn, that something is in front of him, and you typically don't honk your horn until something is in front of you, and after you honk that horn, that doesn't give you a right to continue to move into traffic. But that's exactly what he did. He knew they were there, and it was 68 different people. And this is what I mean when I'm talking about looping. How could you just hit one person and keep on going, let alone hit a second person, let alone hitting a third person, a fourth person, a fifth person, and then a sixth person? And he never stopped. He never stopped to see if any of those persons needed medical attention. Never. She played, strike that. He kept on going, kept on running before the cops. Kept going. He never stated it was an accident when he was in interrogation talking to the FBI agents. He said a story equivalent to he got a ride from a buddy in a tan Kia and got into a fight with Erica, and then he suddenly fled on foot. None of those things that match the facts that were shown by the district attorney as an offer of proof. She showed State's Exhibit 53 playing Jingle Bell, Jingle Bell, Jingle Bell Rock, and captured the environment of the Christmas parade. People were there with family, friends, loved ones on Main Street. She showed another exhibit of the gas station on Barstow and North Street where Brooks was driving recklessly and then got into an argument with another person as though this person was the one who caused Mr. Brooks to act recklessly with his vehicle. And it was important that she showed State's Exhibit 53 because it showed his reckless conduct in driving that vehicle even before he got to the gas station and before he got to the parade. And thereafter, his rage continued. She showed State's Exhibit number 3, the shoving match between Erica Patterson, her friend, and then one of the passersby who came to her defense, where he then acted in a rage and then got inside of his car, the vehicle that was used in this massacre. It was stated that, according to onlookers, he was driving at a reasonable speed, but by the time he gets past East Avenue and Barstow, that's where the carnage starts. First person he struck was Nicole White from Remax. Then runs over the children in green on the side, and then runs over Kelly Greeball, I believe I'm saying her last name, maybe correctly or incorrectly. Hits Deborah Ramirez on the side of the street. Hits Jane Krulak, causing her to land on the hood of the car and then falls over and then drives over her body. Runs over the kids by the steaming cup. Keeps on going. Plows through the grannies, injuring and then killing, and then keeps on going. One of the persons as talked to by the district attorney, investigator, and prosecutors stated that the way that people were flying up in the air was as if a bowling ball had hit them and they were pins in the air, about 15 to 20 people flying in the air like bowling pins. State's attorney Opera stated that she doesn't even know why something like that would happen unless it was rage. I'll save the rest in talking about intent. It looks as though they're getting ready to come back on the record. In intent, they're saying things to the effect of, yeah, you can't read minds to determine intent, but the law doesn't require it. In fact, she showed exhibits looking at the barricades, looking at Officer Schneider with her vest, her neon-colored vest, and how many officers actually ran into the streets in an attempt to stop him to no avail. She plays the video of him hitting Nicole White, and you can listen to the sound of horror filling the courtroom as the marching band was playing, just to be disrupted by the presence of a vehicle running into the parade participants. And the sound of even one of the either survivors or victims or family members in the courtroom crying themselves to have to relive this. She showed the exhibit of the car and that it was, quote, remarkably amazing that that amount of damage happened to that car. State's Exhibit 154 showed shoes laying in the ground because of the velocity of the people knocked right out of their shoes, as testified by the Waukesha County Medical Examiner. And then she goes in to talk about his methods in hiding, how he changed his appearance. He was wearing a hoodie, discarded that hoodie, lost a sandal. The hoodie that, by the way, had his DNA on it. Approaching someone and saying, I won't hurt you, but I need to use your phone. State's not required to prove motive or intent. Motive, at least. They're required to prove intent, not motive, and not intent by reading someone's mind, but intent through their actions, through what they did before, during, and after. She further stated that he took refuge in the home of Daniel Ryder, and some people tried to help. And it was a good thing that they actually did help him, because it slowed him down so that later he was able to be taken into custody. Asked some people if anyone had caught a license plate, had seen a plate of the guy or the car that committed this offense. Same car just happens to be in a music video with his license plate. And when he was taken into custody, an ID was pulled out and off of his person that had his name, Darrell Edward Brooks Jr. An identification card, not a driver's license. And I think that one of the statements that she ended with in closing was that you had the Catholic community of Waukesha who was there spreading the light of Christ that he sniffed out. He sniffed out the life of Christ. And if there's one thing you don't do, among the other things that you don't do, if you are a believer, if you are a Christian, she didn't say this in the argument, but I'm just saying, as a juror, you don't sniff out the life of Christ. You don't sniff out the life of Christ. That's a powerful closing. You said in recess or have deliberations started? No, they're in recess, a temporary break while, I don't know. Maybe it was the reactions to what was said and in preparation for what Brooks is about to do, because you know it's about to go down. It's about to go down. And I am curious to see how this is going to come out or come about. Yep, I'm curious to see how this is going to come about. So, I will read through the comments. I think I still had the poll on. I didn't even stop the poll. Did I stop it already? Yeah, I went on ahead and deleted that message. You're entitled to your belief, but exercise a little decorum or we'll time you out, and then too much will just block you entirely. Right. Clifton Hicks, a little filter, please. Too harsh to say. Right. Don't do that. I don't have time to be canceled because a strong community stronger than me. Right. Troy, what's going on? You said, I'm surprised the prosecutors spoke on him not showing any remorse. Well, my thing is, and we're back on the record soon. Yeah, she didn't say anything about showing any remorse. I'm curious. Yeah. I'm curious about that too. And I do want to say, Bruce, you said you lost your daughter in a similar manner. My condolences from all of us. I believe we offer our condolences to you. And you do have our support in as much as we can give it here. Thank you for being here to express how you feel and be that advocate for your daughter and for other children and for people. Yeah. Yeah. And having been in the band when I was...
The record should reflect that
We're
Mr.
back on the
Brooks
record.
is now present in the main courtroom prior to reopening following the break.
New
I did
poll.
invite him back into the courtroom, and he is here.
Whew.
Trust you are ready with your closing argument, sir.
I'm ready to address subject matter jurisdiction.
No!
That request is denied.
Just for the record, I was addressing it for both courtrooms here in courtroom number, I think it's 20.
Mr. Brooks, I'm going to bring the jury out. Are you prepared to present your closing argument?
I would like for you to prove subject matter jurisdiction.
Go shut.
I'm not addressing that any further than I've addressed already, sir. There's a written decision. I remind you of that.
In that written decision, did I receive, well, actually, I didn't receive anything. Was there copies made?
Mr. Brooks, I'm going to ask you one more time. Are you prepared with your closing argument? I'm going to have the jury brought out. There's no other legal arguments I need to address from you at this time.
I'm informed of what you're saying. I was merely asking, was there copies made of your
Poll
decision?
Poll up.
So my written decision has been filed into the record. That is done electronically. You were provided with a written copy previously. Are you asking for another copy of that, sir?
Yeah, because I don't have it.
As a courtesy, I'll have my clerk print off a copy and provide that to you.
Is it proven subject matter jurisdiction?
Your objection to the lack of jurisdiction has been noted repeatedly on the record. It is a meritless argument. I've indicated that in my written decision as to why there is subject matter jurisdiction, and I will continue forward with the final stages of this trial, which I hope include your closing argument and then the final instructions to the jury.
I would hope it proves subject matter jurisdiction on the record too.
All right, I will instruct the jury to come out. For the record, the written decision is once again being provided to the
I
defendant.
accept for value and return for value this document as it is not based in lawful law. And it does not prove subject matter jurisdiction whatsoever. Refers to
I don't think he is, Scott.
that was filed in
Thank you, Josie
name
Blue.
of a trust.
Thank you, Josie Blue.
Mr. Brooks, the jury has been asked to be brought out. I mean, I requested that they be brought out. They're on their way.
Were you
Please
aware
be
of that?
prepared with your closing argument.
Dude, you get a chance to talk to the jury. Shut up. Sorry, I'm loud. This mic is really
Tacit
good.
agreement that you don't have to answer any questions as a public servant.
All right.
So that is a tacit agreement.
Just shut up and get up, dude. Here we go, y'all.
Reflect, the jury is coming out.
How many of y'all on pins and needles? You know he about to show his whole. He is about to show it.
Thank you, everyone. Please be seated. Go ahead, sir. You may begin your closing argument.
I'm not ready to begin closing arguments.
So this is your opportunity to provide your closing argument to the jury. Please start. I have started the timer of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why. The jury deserves.
Mr. Brooks, this is your opportunity to
be heard.
Closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties as they have not.
Well, you could talk to them.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30 plus pages to read.
Did you inform
They will be informed of the law.
Did you inform them that they can
Mr.
nullify
Brooks?
the law?
Mr. Brooks, you do not have that right to request that. And
Were
I'm
they
advising
informed?
you one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr.
they
Brooks,
are-
you
if
have
they
no
have
right
the
to
power.
make that argument to the jury.
Well, I know he.
True, they have the power.
All right, I'm going to excuse the jury.
They should know that they have the power.
Please rise for the jury.
It's still about to go down once they go behind the door.
Thank you. Please be seated.
Oh.
Mr. Brooks, you do not have a right to request jury nullification directly from this jury. I direct your attention to the Bejerkas case, BJERKASS, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct or to request an instruction or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom. I was able to mute half of what you said the second time, and then of course you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
I haven't made any such choice, so you can't coerce me into a constitutional right waiver when I have not waived the constitutional right. And I will not allow you as a public servant to do that. I have not made a choice.
Sir, the time has come for you to present your closing argument.
Are you making a judicial determination that you're denying me a constitutional right in
I have
open
not
court
made such a
on record?
determination as of yet, but you can forfeit your constitutional rights
Under
by
what
conduct.
lawful law?
Illinois v. Allen.
State versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to rights when talking about
In
closing
State versus
statements.
Anthony, the
Illinois
Supreme
versus
Court of
Allen.
Wisconsin referenced both that decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of those
the
that you just
reasoning-
named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed from the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument. So how's that same statute being used for something that it doesn't even refer to or pertain to?
Mr. Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is State versus Anthony, are two examples of cases where a defendant lost a very important constitutional right.
This is definitely going to the Supreme Court.
Forfeited by the conduct of that particular
And
defendant.
that was to be present in trial, correct?
The right to present a closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by the constitutions.
Which I was denied the
I'm
right
not
to.
prepared to
be
make
able to
that ruling
testify to.
here yet today, but I will tell you this, sir. The time has now come for you to present a closing argument. There will be no further delays.
It's
I
not a
will not
delay.
be taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing
And you
arguments.
made that while
It is
violating my
up-
constitutional
Sir,
right.
please don't interrupt me because
Well,
you've now
you did.
interrupted me a couple of times.
No, once. So let's
Twice.
make that correct. Once.
That's the third time.
Okay, now you can say.
So, Mr. Brooks,
You see how they're going back and forth?
I'm advising you yet again. The
I
time
don't
has now
consent to
come.
being called
That's
that name,
another
Your Honor.
interruption. The time has now come for you to present your closing argument to this jury. You were
And
brought back over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
No, I'm going to let them know that they have rights and they should be told, informed of the truth. It's not me
Are
trying
you
to
telling
give.
me, sir, that
It's
you are
not trying
going
to
to
give.
let me ask you a
No, hold on.
question.
I'm not trying to give any
Sir, you're
jury
interrupting
instruction.
me and you haven't let me finish. So are you telling me that you are going to disregard my very clear directive to you to not bring up the topic of jury nullification?
That's not what I said.
That's why I'm asking you.
I don't understand that question because that's not what I said.
Sir, you may not argue jury nullification
I'm
to
going
this
to
jury.
inform them of the truth.
He is definitely going to argue
Going to
this.
Inform them that they have the power of jury nullification.
Paul,
They do have the, you just said on the record that they have the power for,
Sir, I direct your
you
attention
just said that.
once
Did you
again.
not just say that, Your Honor?
she did say that,
Jury-
just that the parties can't state that.
The jury
On
has
that.
the power, but not the right to nullify.
Right.
A
You said the
Power, but not the
You said
right,
the
and
power.
they can't
Sir, you're
instruct them on
interrupting
that.
me once again.
So I'm going to inform them that they have the power.
Are you telling me, sir,
I'm
that
not
you
telling
are
you no
going
such
to
thing. I just
disregard
told you what you just
my
said.
directive to you to not raise the issue of jury nullification during your closing argument?
That's not what I said. You just read and said that they have the power to. That's what you just said, Your Honor.
Sir, State versus Bejerkus says, and stands for the proposition.
See, the problem is she thinks she's dealing with an attorney when she's not.
Jury nullification.
They have the power.
No party has the right to argue for jury nullification.
I'm not arguing
It's not about the
with you, Your Honor.
right. He's going to do it.
I just want them
Sir,
really to be
You
informed.
can
That's it.
call it informing, making them aware.
Yeah.
Oh yeah, there's zero chance
You're
that
not allowed to make them aware of their power to nullify. That is
How can I
an
not make them-
improper argument.
Your Honor, how can I not inform them that they have a power? How can
Because
I
that is
not
not a
inform them
right
of a
that
power
you
that they
have, sir.
have? I'm not giving a new jury instruction. That's not what I'm
There is
arguing.
no jury instructions for jury nullification,
Yeah, I'm
sir,
not- I'm
because
not-
it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely attempting to inform them of the power that they have.
that's true, James. I
That's
give you
not
that.
against the law.
I'm advising you one more time. You may not raise the issue.
How many of y'all think this is not one more time?
Before this jury.
Inform them of the power that they
She's
have.
gonna do it 2 more
You
times.
are telling me
I'm
that
not
you
giving
are
them a jury
insisting
instruction.
on telling them about jury nullification. That's
That's-
what I hear you saying.
That's not what I said, though. Don't mischaracterize what I'm saying. You just read and said that they have the power. They have the power to do that. So how is
It's an
informing them?
inherent power that they have. They are not to be instructed on it. That is very clear in the law. In
Your Honor.
addition to, no, let me finish. In addition
No.
to the case that I just cited, I cite to you from the jury instructions, the law note on jury nullification 705. What that says, sirs, I'm not going to read it all. It's many, many pages. But the bottom line is, it is improper for a court to allow a defendant or a defense attorney to make an argument or make the jury aware that they have the power to nullify a verdict.
And Your Honor, you just added this last night. That's why I had to sit there for an hour in the holding cell and wait for you to change the whole paperwork because I brought that up. So you never intended for this to even be an issue.
Mr.
It
Brooks,
never was brought up.
if you
But
think
then
I
when I
wasn't-
raised the issue,
If
Your
you
Honor, let
think
me
that I'm
finish.
not prepared to deal with an argument on jury
I didn't
nullification,
say,
then you
that's not what I said. That's
You are
not what I
missing
said.
the
In
mark.
all fairness, that's not what I said.
the record should accurately reflect that you were kept in that holding
Why
cell
was I kept
so
in there?
that my clerk could finish
Adding a jury instruction that was not there.
76 verdict forms, and it's ×2 because there's a guilty and a not guilty
Okay.
for each. No, let me finish.
So how did I have, why did I
repeatedly.
have to sit here for that where I could have just went to my cell and had it delivered? We had this
Mr.
at the end
Brooks.
of last night before you called recess.
I'm not gonna
We
debate
had a
that
whole,
topic with
we
you
had a whole
further.
conversation about
Mr. Brooks, you
me
are
bringing up about the jury
defiantly
nullification.
disregarding this court. You
Here we
you
go
can
with this.
roll your eyes
Here
at
we-
me
because
all
it's-
you want.
It's ridiculous.
Stop
Your
being emotional, Judge. Who
Honor.
cares
You
about the
just
eye
said that
rolling?
They have the power to nullify.
Yes, Julie, you see what I'm saying? Do you see her getting emotional with him?
Sir, the part of the case that's important, but you're not.
He's
letting
getting
me
to her.
forward and edgewise. I'm trying my best not to remove you to the other courtroom, but that is oftentimes what I need to do in order for this court to make a full record without you interrupting me. But you need to be fully aware that you may not raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going to disregard that direction, you will forfeit your right to present a closing argument.
Under what lawful law?
Uh-oh,
Under State
not the
versus
lawful law.
Anthony.
It doesn't refer to that.
State versus Anthony
it
may
doesn't.
not have dealt with
It hasn't dealt with
the
closing
right
arguments.
to a closing argument, sir, but the reasoning
You just said it right there.
nonetheless is
No.
fully applicable.
No, you
because the more
can't change
general
the law, Your
principle-
Honor. You can't change the law. That's
I'm not
practicing law
changing
from
the
the
law,
bench.
sir, but the general
I know you
principle,
used to be in legislation, but you can't practice law from the bench.
sir, I'm
You
not
can't do that.
practicing law from the bench.
You are, if you're changing, Your Honor,
I'm not
you're
making-
attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument. Nothing that you just
So,
named. Not
Mr.
Illinois
Brooks,
versus
I would
Allen.
like to make a record. Would you please show the courtesy and respect?
I will,
to
Your
do
Honor.
that?
I will.
All right. So looking at the Anthony case,
How many of y'all think he will?
and that case starting at head note 7, paragraph 54 says the following, and you need to let me get all the way through it. We have recognized two distinct ways in which a defendant may give up his rights, waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there, I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dina case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture, doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus Allen, 397 U.S.
337. 337, yeah.
They went on, the court, that is the Wisconsin Supreme Court in Anthony. As previously noted, we have held that the right to testify is subject to waiver, not forfeiture, insofar as a defendant's inaction in asserting the right is concerned. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture or conduct incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing the guidance from Illinois versus Allen and State versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor
But he
this ruling
won't.
of mine, then you will forfeit your right to present a closing argument. That is my ruling.
I object to that ruling, Your Honor. I object to that ruling.
You're right. Next
And
time
refuse to
on
make a
Netflix.
closing argument, sir, that does not reference jury nullification.
I'm going to inform the jury of their power. Again, I never stated that I was making a new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Now,
what I'm
one time
telling
did
you,
you
Who's the black guy behind
with
him?
all due respect, I'll let
Did
you
y'all see he
make-
changed?
I didn't.
It was white. Now he's black. Is that the hitman?
Not one case law that you just cited made any reference whatsoever to a closing argument.
That's the head of the
Not
GDs.
one.
I'm just playing. I don't know.
So how is me merely
That's four of them.
informing the jury of the power and the rights that they have? How is that a forfeiture of being able to give a closing argument?
Is he the head of the
well, in
Waukesha
addition to
Sovereign
what
Citizens
I
Movement?
cited, sir, I'd also point you to State versus Bajirkis, 163 Wisconsin 2nd at
Well, that's a
549.
lot of-
That's
that's
a
a
Court
lot
of
of
Appeals
cases.
case from 1991. That is the first published appellate decision in Wisconsin to consider directly several issues relating to the jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but not to go further, and could not argue that the jury, quote, should disregard the instructions and the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification would run afoul even more. And so I am telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility, and to ensure that this jury is presented with arguments that are proper under the law, I am hereby telling you I am in creating a rule for your closing argument.
You should not have told him creating a rule.
Raise the issue of jury nullification in any way.
Your Honor, hold up.
He took his mask off.
I'm the only one that has to be made rules for closing arguments, but not the prosecution. How is that fair? How's that balanced?
Mr. Brooks, I'm squarely faced with your defiance regarding the issue of jury nullification
It's
that
not
is
defiance.
requiring
It's
me
not defiance.
to address this issue and to tell you very
Your Honor,
expressly
I
that that is the
vehemently,
rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to that.
Your objection is noted for the record, but
May I
my
ask
rule
for legal
nonetheless
reconsideration of your
stands.
ruling?
That request is denied.
May I respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling. For the record, may I request a legal or factual basis for your ruling? Not one pertaining to being present in the courtroom or testifying. One that specifically talks about a closing argument.
All of those requests are noted. I will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law?
Denied.
For the record, may I respectfully move for an interlocutory declaratory appeal on this matter?
I'm not the forum for which an appeal would be sought, sir. I cannot
Well,
answer that.
You referred to it before.
You would need
So
to
now I'm
direct your
confused.
appeal to
I'm
a
confused, Your Honor,
court of
because
appeals, not this court.
no, this is, I'm supposed to be in this admiralty court because you haven't, if we're under Article 3, then we should be in common law court. That hasn't even been addressed if we're in a common law court or an admiralty court.
That's a baseless argument, sir. I don't even need
And
to
what law and
address it.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Sir, I intend to bring this jury out and give you
I'm
an
informed
opportunity
of that.
to present a closing argument.
Yeah,
If
but
you
you're
violate,
also-
please
you're
let
also-
me,
but
sir,
listen,
you're
you just
interrupting me
made a
yet
rule.
again.
You just tried to put me under a rule that no one else was put under.
The circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't,
on
Your
the
Honor,
issue
that's a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the same rules.
Sir, the
has to be
circumstances of
fair.
this case and your insistence on arguing jury nullification has resulted
I
in this
haven't-
court creating this
I haven't
rule.
argued it. I said that I wanted to inform the jury of their power. I never once said, I'm going to make an argument. I'm going to give them a jury instruction.
You may not
never
advise
said
them
that.
or make them aware in any way that they have the power
And why not?
jury
Why can't they be
nullification,
informed of their power?
because it would violate the Bajirkas decision, sir.
Violate what decision?
All right, sir, I am going to bring the jury
And I'm
out.
going to inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare that your right to present a
can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based
And
upon,
I make a
how I've
oral
outlined that to
motion
date.
for
I'm
legal
not going to
finding of
declare that
facts.
at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't
to
do that.
present a closing
Under what
argument.
lawful law can you,
And then if you continue to
under
interrupt
what
me,
lawful law?
you will be removed to the other courtroom as I
So I'm
complete
being
the
held in contempt
instructions.
again. Is it civil or criminal?
All right. Go ahead.
I apologize. May I ask the court to consider perhaps an alternative, and I fully respect the ruling the court has just made, and I understand the basis for it. We all know the defendant in his petulance will say jury nullification in the first 3 seconds the jury's in the room.
Objection to that.
Proper
I don't
thing
think
to
that
do,
I
I
should be
think,
talked
Your
down
Honor.
Stop
to.
interrupting
I don't
Attorney
think I
Hopper,
should be
please.
talked down to.
Allow him to make his closing arguments. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing argument. But we could at least try to, by merely objecting and the court telling the jury to disregard and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction. This court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence. And I think they will abide by that. So I know it's going to require effort for the court to allow this to allow Mr. Brooks to try and proceed, but I think we should try that or something similar to that in an effort to get through this next step, or else we will continue at this pace forever.
Outstanding.
I'm certainly willing to try that.
It's about all we can come up with, Your Honor.
And I'm certainly willing to try it in this courtroom, and then if he disregards that, to excuse the jury and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
Outstanding. I agree.
Your Honor, I object to that.
Who cares? Let's go. Let's go, baby. Yes.
Your objection is noted.
Y'all better vote for District Attorney Sue Opper.
Action that this court takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in a blatant disregard of the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
Noted. Overruled.
For the record, may I respectfully request the legal reconsideration of your.
Just let him talk. Let him talk. Yes, I agree, Scott Boys.
That you don't have to answer my objection.
Yeah, just keep going. Just keep going.
I decline to reconsider.
I reject that ruling and take exception to that ruling, Your Honor.
Just keep going.
Noted for
Let him embarrass himself in front of the jury.
Factual basis for your ruling, Your Honor.
denied.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue, Your Honor.
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter.
Denied.
I'm not the court to address that.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction.
Noted. Denied.
Under,
The jury's
based on what
coming in.
law or
All
fact?
eyes for the jury, please.
Based on what law or fact?
Put your shirt inside your pants.
I'm going to inform the jury of their power. They deserve to know.
Put your shirt in your pants, boy. I mean, sir. Put your shirt in your pants. Where'd the black guy go? Oh, he's right by Brooks. Okay. It's the remix. Objection. Hot and fresh out. Objection. Got me rolling my body. Objection, objection, objection. I'm sorry. Don't mind me.
Thank you,
Oh,
everyone.
man.
Please be seated.
Subject matter jurisdiction. And I gotta object.
Go ahead, Mr. Brooks, your closing argument, please.
Good afternoon. It's been a long day.
You think?
First off, I'd just like to start by letting you guys know that it's a lot of information that you guys should be privy to, I believe. And one thing that I believe that you have not been privy to is the truth of your rights and your duties. Being the jury. The fact that you and you alone have the power.
The power.
Not
the power.
Well-prepared DAs with
Don't you do it.
Well-prepared and clearly rehearsed
Don't you do
speeches and exhibits and a lot of theatrics. Frankly, not the judge.
Not the judge.
You and you alone have the power. You and you alone decide what is truth and what isn't truth.
That is true.
You should be informed that you have the power to nullify any law that you don't agree with.
Objection, move to strike the statement.
Sustained.
Objection.
I will strike from the record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law. The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech. I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart in my opening statements, and now I'm going to speak from the heart. What you won't hear me do is argue facts. And the reason you won't hear me argue facts is because I believe that it takes away from what should be recognized. The tragedy of this event. It should be recognized. Trying to argue facts of this, facts of that, I'm not going to waste your time doing that. It's a little emotional. I apologize for the long pause. It's hard to keep everything together emotionally. And honestly, I don't believe that I have any more tears left. It's been a hard year. For the families, mostly. And that should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. It's a lot of people that are healing, that are attempting to heal. opens the door to talk about forgiveness for a little bit. With every healing process, there comes a forgiving process. It's not an easy thing for anyone. What you've been hearing from the prosecution, not to take anything away from them, but let's call it what it is. You've been hearing a lot of rerunning. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing it? That's what's been happening. Rerun over and over and over and over and over and over and over. Attempting to make things stick in your head that simply aren't true. Why do I say, what am I saying? Say, look at the testimony. You know, the thing from the prosecution here has been intent, 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 intent. We all know what's been said. We all know the picture that's been painted. Even the prosecution said themselves. How can you look in somebody's head and say, this is what they intended to do? You know, for a year, I've sat and gone through this. Feeling so powerless. Letting other people run with the narratives. Sitting back helpless while other people paint a picture that has zero. I understand about healing myself, tragedy, pain, all that. A lot of it, there's no need to get into. I myself in my own life have had to do a lot of healing. As a man with children myself, I find it hard to believe that anyone who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act. I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn. While attempting to alert people of their presence. Which brings me to more information that I believe that you should have been privy to. and I'm sure that the prosecution will beg to differ. But the fact of the matter is, the vehicle in question, make and model 2010 Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection, statement of facts, facts not evidence.
Was in fact
Sustained.
Recalled. Was in fact a class action lawsuit against Ford
Objection,
for those model vehicles.
Sustained. The jury will disregard.
Information that you should have been privy to, that you weren't allowed to be privy to. Why? I don't know. That information, malfunctioning throttle bodies.
Mr. Brooks, move on.
It's information that you should have been privy to. Vehicles that malfunction and accelerate not being able to be stopped.
Objection, that is.
It's information. It's information.
Objection. Hold on. Go ahead.
We've just read statements by.
Sorry for the interruption.
Facts not in evidence, Your Honor, is Gipley misstatement.
Sustained.
How's it a misstatement when I have the information?
Mr. Brooks, move on.
This is information that I feel like you needed to know. You should have known. Information that was taken away from you. Why? To prove a case? Information that you definitely should have been privy to. DA says the defendant has an utter disregard for human life. Utter disregard for human life. Not realizing that they're talking about someone that has children. Talking about someone that watched their children come out of the womb and be born into this world, cut their umbilical cord, held them before their mom even did it.
You might have a point for it, Dags.
Moments that I'll never forget.
You might have a point.
And yet they say disregard, utter disregard for human life. They made reference to a rage, as if they were, or if this particular DA was right there, standing right there, as if this DA is a psychiatrist. I say to myself, what rage? What do you mean rage? How can you characterize that?
There's nothing on the brake system. No recalls on the brake system. I just looked it up on
How
cars.com.
can you have the audacity to diagnose what someone's brain is, where it's at, what it's thinking, why it thinks the way it does? DA makes references to blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage
the supposed intent to harm and kill. And it doesn't kick in until well within blocks. And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger, then why weren't people immediately harmed? Why would someone with intent to kill and rage try to alert people of their presence, repeatedly honk their horn? You heard a detective, if you recall, testify that the vehicle that he observed was not only honking his horn, but was not speeding. So where does this rage kick in? Where does this insatiable intent to kill kick in? They speak as someone who's known someone for years. Which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
Objection, fact, not evidence.
What if the driver of the vehicle was unable to stop the vehicle? Because of that fact, what if the driver may have panicked? Does that make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people? DA played a exhibit 17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck. Was someone who had this intent to kill, this rage, as she says. If that was their intent, wouldn't they have taken the opportunity to hit as many people as they could? Target people, mow down people. Reference was made to this vehicle, the damage. Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. You've heard testimony about hearing loud crashes and things of that nature, but the DA wants you to believe that this all came from people. Evidence doesn't support that.
Great job. Yes, good job. This is good.
So I go back to trying to wrap my head around everything that's happened in the last year. Praying for those families, praying for the people that tragically lost their life, because that should not be lost either. The fact that there was lives lost and all the emphasis has been put on the alleged defendant. And the people have been disregarded. Makes me wonder, Does the DA even care about those people?
Hey, wait till they come.
There's been prayers going up every day. It's been suffering on both sides. It's been threats, hate mail. Because of the narratives that's been put out there, the misconceptions that have been put out there, the lies that have been put out there, lies that have caused my children not to be able to go to school, to be bullied, for my mother to have to leave her home and stay at a hotel because she's afraid for her safety, because she gets hate mail shoved through her mailbox. My nieces and nephews to fear for their safety. And what's been equally hard is not only having to answer the questions from my daughter, who was 7 at the time, my baby girl, who was 7 at the time, is now 8. Attempting to answer her questions that she's asking, and still continue to shield her from what she sees, what she hears. Having a newborn son that I haven't even been able to meet. I haven't been able to hold, touch, kiss. Having to navigate everything that comes with this whole situation. While still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell, especially during lights out, alone, where it's just you. And just been praying and asking myself, how could this happen? Not just for the people, but for everybody involved, the community too. How could this happen? How? The hardest questions you can ask is those that don't have an answer. No matter how much thinking you do, no matter how much you try to look at it from different perspectives and listen to other outside perspectives and listen to people that you trust and that you love, still coming up with nothing. think for 1 second, one question I never had to ask was if this was intentional. That's something that I never asked once. Because I know it wasn't. As a matter of fact, it never even crossed my mind to even attempt to ask myself that, because I know it wasn't. And I know sometimes during this trial probably doesn't show. Maybe hard to believe. But trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine. So again, I go back to all these exhibits. Go back to everything that's been shown, everything that's been testified to. Everything you've heard during this whole process, this trial. And again, I say the same thing that I said earlier. Same thing I said in opening statements.
No, that's my music.
I'm not reading from any paper, any books. Everything you've heard in opening statements, everything you're hearing now is from right here.
Tu corazón.
Everything.
Tu tu corazón de la muerte. El diablo con no.
You have the decision. You and you alone. All of you. You have the decision. I'm sure you've taken a lot of notes during this process. Some days are longer than others. A lot of movement in and out of the courtroom for various reasons.
That is true, Clifton. That is basically what he's doing. Yes. This is a filibuster. It's going to be a time waster. Where's COVID, Larry?
Remember the power that you have.
Damn, here we go.
Don't for 1 second let it be taken away from you. I can never understand the position of sitting on the jury in something of this magnitude. So I'm sure there's a lot of pressure. I pray that the right decision is made. right decision.
Oh, they're gonna make that right decision.
It's almost like that message.
Got the
Not
message.
message, but that writing. When we're in our vehicles and we got that rearview mirror and it said things are closer than they appear. But it's also another way of saying sometimes things aren't as they appear.
Why did he have to reference a car?
I can't speak for anyone else, but me, myself, I believe in Jesus Christ.
Not the light that you snuffed out.
That's how I was raised. That's what I believe in.
Jesus Christ.
None of us are perfect. But I try every day to make sure that I acknowledge him. That's why every time I step in this courtroom, I have my Bible with me everywhere I go. I even read it on breaks, recesses. This is not something that started at the beginning of this incident. This is something that has been instilled in me since I came out of the womb. This is how my family lives their life. This is how we was raised.
They're gonna eat his ass up on rebuttal.
For whatever mistakes that I myself have made in my life, I've made peace with God. Made peace. I'm happy to say that my conscience is clear. And because I believe, I trust him with my life. Nobody will never know why it was his will for this to happen.
It was his will. Shit. His will. Did you say will?
A lot of lives were changed that day, mine included. God's way is not our own. And no matter how much sometimes we want to question, we have to have faith.
Brian said, I have faith in the jury.
Myself. Look inside yourself and make the right decision. inside your heart. You have everything in your hands now.
Not yet, but soon. It's coming.
Everything.
I don't know.
Do what's right. Do what's right. Don't let the smoke and mirrors take away your power.
Not the power again.
Matrix take away your power. Each and every one of you has a decision. Who's right? Make the right decision.
COVID Larry is striking again.
It's hard to think about. My younger kids getting older and at some point having to explain everything to them.
I agree. 2 days max.
Kids don't stay kids forever. And nowadays, kids is frankly a lot smarter than we were when we was kids. I'll tell you that much. I got a letter the other day. My youngest daughter. And she's still learning cursive right now, so she's the best writer when it comes to cursive. She'd rather print. She said, "Dad," and this is from the letter. She said, "Dad, why are people saying all these mean things about you?" I haven't read the rest of that letter yet. The rest of that sentence said, "That's not the dad I know." this year I've been called a lot of things. And to be fair, I am a lot of things. A murderer is not one of them.
No, that's a stretch.
Never has been, never will be. So before I close my statement,
Let go. Before I let go.
just want to say open your hearts.
Open your hearts.
Go inside yourself when making this decision.
Go inside yourself.
I have no fear. Pray and do what you know is right. You know is right. Think about everything you've heard. Think about everything you haven't been privileged to. Think about the whole entire picture. Love everything. Whatever you decide, make sure you yourself can live with it. Make sure you can live with it. That's the magnitude of the power that you have. Just like this tissue is in my hand, this is everything. You have everything. Be at peace with what you decide. Have no regrets. Don't let this decision weigh on you after it's over. Hopefully we got a lot of living ahead of us.
Byron, what is wrong with you? You changed your picture.
Lord willing. Don't look back and kick yourself in the behind. It's been about 3 weeks with you. And it took a lot of courage and a lot of guts to pause your life for this. To put important things on hold, to basically stop your life. You should be commended for being able to sit up here with this amount of pressure. I want you guys to know that's not lost on me. I'm sure it's a lot. And you all should be commended because it took courage to do this. I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now. And you guys had the guts to do it. Thank you for that. Thank you for taking pretty much a month and setting it to the side for this. I know it's probably not proper, but you guys deserve a round of applause if you could give one. Thank you guys sincerely, and I know, and I have faith and I trust that you guys know what's right. Ladies and gentlemen, I don't think it's fair to just say guys, but I believe in your heart you know what's right. Thank you.
Thank you, sir. Before I give the state an opportunity to present rebuttal, please stand for a minute. So please stand.
Boy, you know this rebuttal about to go in, boy. Oh, she about to fire. And you know this is coming from the... Whoa! All right. Here we go, son. Boy, you know it's about to go down on that rebuttal. The passion
Have
of...
a seat, please. And Attorney Opper, I did time both closings. You have 13:28 left.
Thank you, Judge. I don't think that'll be an issue. Folks,
We got to give her some music.
Mr. Brooks stands here and professes to speak to you from his heart. He plays on your sympathy. He talks about his children. He talks about the hardships that he's encountered and his family's encountered. And he brushes over the loss to the community. He wants to talk about how he's never held his newborn son. Never once acknowledges the Sorensen family, the Owen family, the Duran family, the Hospital family, the Kulik family, the Sparks family. Never once. It's nice that Mr. Brooks can get letters from his loved ones. I don't know why he did this. I told you that. But actions define a person. It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down, your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known. You don't have to stand and wonder as he claims to. For him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going. And have Jane Kulik fly off the hood of his car, run her over, and keep going. I'm not going to go on. You get it. You need to look in the mirror, Mr. Brooks. If you want to accuse me of practicing my closing argument, you need to look in the mirror, sir. Your actions are that of a murderer. You murdered these 6 people. You endangered the safety of 61.
Technically, she's not supposed to be talking to him. She's supposed to be talking to the jury. And if he had a defense attorney, that would be an objectable
I woke up one day and don't know how
moment.
I found myself in this position.
But let's continue. She's not supposed to directly address him
If you have some explaining to do to your children, Mr. Brooks, I recommend you do it.
I'm not advocating for Mr. Brooks. I'm just saying she's not supposed to directly
the duties
address
of the parties and the court have been performed.
Okay.
The case has been argued by the parties. The court has instructed you regarding the rules of law, which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice.
There's so much more she could have said. So much more.
Be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 76 forms of verdict will be submitted to you concerning the charges 76. Against the defendant, Darrell E. Brooks. Count 1. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 2. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 2 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 3. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree intentional homicide as charged in count 3 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree intentional homicide as charged in count 3 of the information. If you find the defendant guilty of first degree intentional homicide, answer the following question, yes or no. Did the defendant commit first degree intentional homicide while using a dangerous weapon? Count 4, excuse me. Count 4, count 4, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree intentional homicide as charged in count 4 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree intentional homicide as charged in count 4 of the information. If you find the defendant guilty of first degree intentional homicide, answer the following question, yes or no. Did the defendant commit first degree intentional homicide while using a dangerous weapon? Count 5, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree intentional homicide as charged in count 5 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree intentional homicide as charged in count 5 of the information. If you find the defendant guilty of first degree intentional homicide, answer the following question, yes or no. Did the defendant commit first degree intentional homicide while using a dangerous weapon? Count 6, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree intentional homicide as charged in count 6 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree intentional homicide as charged in
I don't
count
think
6
anybody
of the
gonna protest
information.
his verdict.
If you find the defendant guilty of first
Sorry.
degree intentional homicide, answer the following question, yes or no. Did the defendant commit first degree intentional homicide while using a dangerous weapon? Count 7, one reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 7 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 7 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 8, one reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 8 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 8 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 9, one reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 9 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 9 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 10, one reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 10 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 10 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 11, one reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 11 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 11 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 12, one reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 12 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 12 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 13. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 13 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 13 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 14. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 14 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 14 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 15. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 15 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 15 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 16. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 16 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 16 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 17. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 17 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 17 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 18. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 18 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 18 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 19. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 19 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 19 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 20. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 20 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 20 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 21. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 21 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 21 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 22, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 22 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 22 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 23, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty.
You're fine, Bruce. You're fine. Love you too, buddy.
As charged in count 23 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 23 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 24, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety is charged in count 24 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 24 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 25, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 25 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 25 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 26, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 26 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 26 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 27, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 27 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 27 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 28, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 28 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 28 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 29, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 29 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 29 of the information.
Oh, just 29.
If
Jesus.
you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 30, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 30 of the information. Another reading. we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 30 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 31. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 31 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 31 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 32. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 33 of the information. That should be 32. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 32 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? I'm going to have you take a short stand break while I confer with Madam Clerk.
Well, thank you, Bruce. I'm not falling asleep. I'm definitely up. I'm just multitasking. I've got a class right after this.
Yeah. Okay, well, you could read one twice and then I'll make another one.
When you're ready, have a seat. Count 33. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 33 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 33 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 34. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 34 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 34 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 35. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 35 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 35 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 36. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 36 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 36 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 37, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 37 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 37 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 38, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 38 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 38 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 39, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 39 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 39 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 40, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 40 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 40 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 41. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 41 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 41 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon?
Yeah.
Count 42. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 42 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 42 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 43. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 43 of the information. Another reading, we, the jury, find the defendant.
All right. Do you all want to stay for the rest of the reading?
Endangering safety as charged in count 43 of the information. If you find the
No,
defendant
let's stay for the rest of it. It's
recklessly endangering safety,
something
answer
happens
the
all the
following question,
time.
yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 44. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 41 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 44 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 45. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 45 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 45 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 46. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 46 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 46 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 47. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 47 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 47 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 48. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 48 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 48 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon?
Start over, Katie.
One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 49 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 49 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree
Thank you,
recklessly
CC.
endangering safety while using a dangerous weapon? Count 50. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 50 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 50 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 51. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 51 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety
Who's the troll?
as charged in count 51 of the information. If you find the defendant guilty of first degree recklessly endangering safety,
Who's the troll
answer the
brigade? Who we
following
talking?
question, yes or no. Did the defendant commit first degree recklessly endangering safety
yeah, I
while
see.
using a dangerous weapon? Count 52. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 52 of the information.
Got it.
Another reading, we the jury
Got
find
him.
the defendant,
I got
Darrell E.
him.
Brooks, guilty of first degree recklessly endangering safety as charged in count 52 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 53. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 53 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 53 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 54. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 54 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 54 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 55. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 55 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 55 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 55 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? I think I'll give my jurors one more stand break.
Oh my God.
So please stand, and anyone else in the courtroom, please. You can have them.
Well, ain't no need for theatrics now.
And here's, if you want these. No. That's more.
Oh, yeah, just read it over.
Oh, did it? Yeah.
No, you're not, period. I'll send it now.
All right, thank you. Have a seat. Count 56. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 56 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 56 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 57. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 57 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 57 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 58. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 58 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 58 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 59. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 59 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 59 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 60. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 60 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 60 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 61. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 61 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 61 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 62. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 62 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 62 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 63. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 63 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 63 of the information.
He been
If you
calm.
find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 64. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 64 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 64 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 65. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 65 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 65 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 66. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 66
Oh,
of the information.
math boy fly. Is it moth boy fly?
I'll just repeat count 66. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 66 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 66 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 67. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 67 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 67 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 68. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 68 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 68 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Virginia Sorensen? Count 69. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 69 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 69 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Leanna Owen? Count 70. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 70 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 70 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Tamara Durand? Count 71. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 71 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 71 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Jane Kulik? Count 72. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 72 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 72 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Wilhelm Hospital? Count 73. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 73 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 73 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Jackson Sparks? Count 74. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of bail jumping as charged in count 74 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 74 of the information. Count 75. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of bail jumping as charged in count 75 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 75 of the information. Count 76. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of battery as charged in count 76 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of battery as charged in count 76 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the parties before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court.
Orally.
When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdicts will be read into the record in open court. The court may ask each of you if you agree with the verdicts. Before I swear the officers, we will determine the alternates, and then I will have all of the civilian bailiffs and deputy bailiffs that will be in charge of the jury during their deliberation and sequestration.
He wasn't too hinged.
Have a lot of stuff up here.
It was long, but he wasn't too hinged. Let's not talk too soon. Let's not talk too soon. What are they about to do? Oh.
So we have placed each one of your numbers in the tumbler. I'm going to draw 3 numbers. Those numbers will be the alternates, who will nonetheless be sequestered in the event we would need to call upon one of you to replace another juror.
I object to the way you are grabbing
First number
those
that I'm
numbers.
pulling out is 10.
I object to 10. That is a number before 9, but not between 11 and 7. Yeah.
The second number I am pulling out is 30.
Objection. 30 is the Antichrist. It's the Antichrist.
And the
Can I
third
get an
number
interlocutory?
I am pulling
You know what?
out is 1.
1
I want to confirm.
as in
that I
singular
don't have 12.
sensation.
I know Madam Clerk did it, but I will also do that to be sure.
Grounds. I can't believe it's not butter. Boy, this is the quietest that he has ever been. This is the quietest that he has ever been. When a wall is better.
And I just confirmed that the other 12 numbers were in there.
Is it too late to talk about?
I'll put those back in and then we'll make a record of that. All right, then I will need all of the deputies and civilian bailiffs to come up and be sworn on the record for the sequestration, and I'll go ahead and do it.
Oh. I object. He should not be wearing tan brown pants. He should be wearing Dockers.
clerk of court pause, why don't you join them just in case you're needed?
Yep, I definitely have a class. They are in the
All right,
room
Joe,
waiting right
please
now
raise
in
your
Zoom.
Right hand. Do you swear that you will keep all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them or you speak to them yourself, except to ask whether they have agreed on their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God? All right, and then Madam Clerk will just make a record of who you all are. It will take us a moment just to have all the finalized paperwork to go back with the jury. We do have all.
I am including the links in the comments if you all do want to support, if you've appreciated this content, this streaming. I am just honored by your presence being here as well.
All right, and here are jury instructions as well. The record is 6:24. All rise for the jury as they're excused to begin their deliberations.
And he rose without comment. Boy,
But yeah, I'm gonna need.
he is quiet now.
But those are the.
He is not asking for subject matter jurisdiction, intergalactic appeal. He's not even asking for a banana peel, an orange peel, hell, Ken peel. He isn't asking for nothing.
Thank you. You may be seated. Just so the record is clear, the alternates, of course, will not be participating in the deliberations. They will be in a separate jury deliberation room and will only be called upon if needed, of course, after consultation with the parties. As far as how late I will let them deliberate tonight, we have ordered dinner for them. I believe it will be here shortly. And I really will leave it up to them as to how late they want to deliberate before they would want a break and then to retire for the evening. They are under a sequestration order, so they will be kept separate and apart. Their electronics have been confiscated, and they will not be going home until verdicts have been reached or they are discharged from the court, whichever would occur sooner. Anything else the parties would want me to address at this
Darrell,
moment
you better not say one word.
on the state? Anything from you, sir?
Yep.
No. Damn.
So essentially, I would have to stay here while you're delivering.
Boy, you in custody.
Go back to my unit, use the phone, shower.
That's a fair
It
question.
is shower day for my pods. I want to get 2 shower days.
I don't, so here's.
2
what could
shower
happen, though, sir.
days.
I don't have a problem with you
2
doing that,
shower
but they could have
days?
questions. And then, so,
So I'm
and
gonna
then
fire
you
your
would
balls.
need to become available so we could address any questions. They may ask for exhibits, things of that nature. So as long as you're willing to come back for those things, I don't have an issue if, you know, I probably should talk to the COs or at least the sheriff and make sure I'm not stepping on their toes since they're in charge of all of that. But it's possible that we get a request for exhibits, some exhibits initially. I wouldn't be surprised if we got that. So let me do this. Let me confer with the sheriff's department. I don't initially see an issue with that, but I want to make sure that they have a protocol in place.
So his balls be
That's what they would
ripe.
like to do as well, okay?
And one more thing.
Oh no.
I was curious. 61 charges for reckless.
Boy, it's too late. It's in the hands of the jury, son.
61 injured parties did not testify. So how does that work? essentially, how are charges able to be charged if all of the injured parties did not testify?
From my perspective, sir, the state presented their theory of the case, and there was sufficient evidence regarding the charges to go forward to the jury. I can't further explain it from there because that would require me to explain the law. And I guess that's all I can really say about it at this point.
I got a point though.
I'm sorry?
I got a point though.
He does.
I'm not gonna comment on that, sir.
He does. It's a little too late though, but he does. And he raised that issue too late.
And
66 victims, and they haven't been identified.
For better or for worse, sir, I was not presented with any motions to dismiss, either at the end of the state's case or the close of the evidence.
He does have a point.
Any legal arguments you may have had regarding those issues. And so
we have only heard of the 6 victims who were
the jury has
killed.
The case.
We did not hear of the other 66.
If there are issues of law that you want to raise after the verdicts are received,
the victim has to be
we'll
identified.
have to make that determination.
He does have a point.
That has to be raised because essentially you can't, if no injured party testifies, then it shouldn't be a charge.
I disagree with that characterization, sir, but there is frankly no motion in front of me based in law or fact. So for me to comment any further would require me to.
And they are not killed. They are alive.
Willing to do.
So you're saying I need to make a motion?
So what I will say.
No. We heard about the injuries and them, but
I do have one issue that I would like to raise with the parties.
He might have a point.
I frankly I need a break a little bit. I mean, obviously the court has to.
Especially if they're alive and ambulatory.
I know my dinner is coming. And I think it's reasonable. I need to put a few things together, but I do need to make a record of some information that I received earlier today.
But that's some. Out of 66, all of them are minors.
I will do that.
How many could have come to court and testified?
Let me confer with the sheriff's department about your request.
See, that's the one thing I like about being neutral.
I'd like to.
I'm not
take about it.
One side or the other. You know, I'm not defending him,
that I need
but
to
he
address
does
or the
bring
issue.
That's an excellent point.
I want to find out if that would interfere with your request about taking a shower and all of that. So if you can hold tight and stay with us for a little bit, that would be great. And I'll confer with the sheriff's department and have a more definitive answer for you shortly. Okay.
Can I get my filings?
You want the originals back. If Madam Clerk has scanned them all in and they're uploaded, I don't have an issue giving you the originals back. They will have the date stamp. They don't have a time because they were filed in court.
When he put the time on, I also, so that you knew they were in there, printed them after I scanned them in, so it has a document number.
So you're getting 2 copies. So you'll have that, okay?
See, I didn't interrupt you, see?
I'm sorry?
I said, see, I didn't interrupt you.
Thank you, I appreciate that. Unless I would like the parties back in about a half an hour. Thank you, unless they have a question sooner.
Your Honor, do I have to go in that holding cell or do I got to get to go?
All right, so we will not be back in a half an hour, but we will be on jury watch tomorrow. And the minute a verdict comes in, I will go live the minute a verdict comes in. But for now, I need to get back to my class, which I have waiting right now in Zoom. That's why I like using Apple products and stuff like that. I'm able to have both running up simultaneously. So I appreciate you all. Thank you very much. And yeah, I'm going to get out of here so I can go on ahead and derobe and then get right on to my class. You said, wait, what are we waiting for? One question. All right. What's your question? Well, I can't could I let the stream continue? And then, yes, why you retain counsel? Well, yeah, there.
Mr. Brooks to the court.
All right.
In it, he indicates.
Let me stop this. All right. Yeah, they've even stopped the live stream. So, all right. So, what was the question? Is your robe an old graduation gown? No, it's not. It's not a. See, I have my master's, and this isn't long enough for my master's. Master's, it usually comes here to the cuff, and then it drapes down, and it has some little hooks or something like that. Because I have my master's, this is neither master's or bachelor's. It's just a black robe that judges actually use. They have different judges use different robes. So I was able to buy one. Love you. Keep healing others. Yes, thank you very much. All right, I'm out of here. Thank you all. Those of you all who donated, thank you. I appreciate that. Yes, and those of you all who participated in the poll that stuck throughout the entire trial. You said you figured that was a naughty judge costume. You all are something else. You all are something else. All right, let me get out of here. Until then, until the verdict comes back, court is in recess.